For verification, the similar matter is lordship fixed on 20 lordship along with DA number 2220.
Arising out of same FIR. Okay. Heard Mr. MZ Shah, Learned Counsel for the accused. Mr. D. Bhuya, Learned Senior Counsel from additional PD, assisted by Ms. So-and-so, Learned Counsel for the respondent. This application under Section 483 of the BNSS 2023 is prepared by accused Sahinur Ali, alias Mohammad Sahanur Ali, alias Zelo, who is languishing in Jailazut since 5/7/2026 in connection with Saptagram PS case number 69 of 2026 under Section 70 within bracket 2 BNS, read with Section 6 of the POCSO Act. So, sir submits that similar matter is listed on
28.
28.
20.
28. BA number or AB number?
20 August.
20 August.
20 তারিখ
Along with BA number 2220.
20 না 28 এটু ক
20.
এটু ক কুঠি আছে
And accordingly, he submits that this matter may also be listed on that day. And to peruse the case diary, to dispose of the present application also. Parallel to SSL list this matter along with BA numbers so and so on 2322. And on that day, CD will be perused to dispose of the present application also.
Item 43.
Please, your lordship. Yesterday, lordship has directed us to produce the
Yes, yes.
copy of the marriage certificate.
Mhm.
But that marriage certificate already been seized by the investigating authority. That is the seizure list that is indicated in the description itself. That one original notarial certificate containing marriage agreement between so and so has been seized, madam.
Mr. Bhattakur,
Yes, ma'am.
you say if the informant victim is the victim and accuser husband and wife, whether the allegation, whether the offenses under which the case has been registered will be applicable here.
Yes, my lord. Both are if my lord now, my lord, at present if living as husband and wife, my lord. Certificate is already the only difficulty is that my lord, after perusal of the CD alia, your lordship has
No, earlier that fact was not brought to the notice of this court.
yes,
madam.
yes.
Okay,
lordship
we will
may
pass
pass
the
it.
order.
Your lordship may pass it.
Pass the order.
Problem.
Items 44 and 29.
I was informed in the morning by Mr. Gogoi that he needs 2 days' time because that CD has not come. But I believe 44 is connected, my learned friend is appearing in this. I'm only requested if it's not inconvenience to be listed on Thursday if it is not inconvenient.
This matter.
This matter, yes. ma'am.
Okay.
If it is not inconvenient.
Okay. Is agreed by learned counsel for the petitioner. Justice shall raise this matter on Thursday
Thursday, ma'am.
along with BA number.
Mine is 2338. 2332, ma'am.
Okay. Okay.
Extremely grateful.
Cover.
Item 2.
This matter has submitted case lordship. This is case lordship, scan copy of the case diary may be called for.
From which court it will come?
Lordship from
Mankasar.
CGM lordship, additional CGM South Sudan Mankasar in respect of PRC case number 181, 2026.
Okay. Scan copy of the record. Fixing the matter of COVID.
One item.
3rd September.
3rd of September.
Item 3.
And this is a second application, my lord. There is a change in factual and legal circumstances. Lordship, please come to page number 29 and 30, my lord. There were four, my lord, FRNM accused, two were arrested. And from the page 29 is the order of the magistrate, my lord.
Earlier rejected.
Status report was called for, my lord. And page 30, lordship will kindly see, after recording the statement of independent witnesses, no any material was found against the other accused persons named in the FIR, my lord.
Page
Two were
number?
arrested, page 30, my lord.
No, the case is surseated thereafter.
No, not my lord. On 12, my lord, we have inquired, it is not subsidiary.
Earlier rejected by.
Earlier rejected by
Your lordship on 18/12/22, page 26.
No, got it.
And this order is 4/12/2023.
Till now, it has not been surseated.
My lord, that, my lord, I will have to get instruction, my lord, why since then, my lord. Charge sheet
On
not-
4th and 11th, my lord, the
That's it,
petitioners
my
were called, my lord, August, my lord, the petitioners were called to the police station. The police came in search of them.
Your lordship may fix it too, my lord. I will.
You have appeared there.
My lord.
You have appeared before that?
No, they have not appeared, my lord.
Okay. Okay, let him obtain instruction whether surset is submitted or not.
Your lordship at two, my lord.
Okay.
My lord.
Okay.
Item number 45.
May I please?
Hmm.
Well, it's a pre-arrest bail application. Well, this is a case regarding to the recent boundary dispute between Arunachal and the Assam. And Lordship knows that there is some miscreants has openly fired at some of the people, villagers, and to that effect, FIR has been registered. Lordship will find FIR at page 26. I am the DSP not posted in that particular area. I'll come to that, not even page 26, my lord.
Yes.
With due respect, I beg to state that today at 10/8/26, Monday, at around 9 AM near Assam Arunachal border, so-and-so, Badati Gaon, Assam, some miscreants were allegedly erecting fencing on the ongoing land dispute between Arunachal border, so-and-so Gaon, Assam. Then group of persons see Bitu Tire Bhaiya went to protest the state illegal activities. During the protest, we were called for the discussion and the disrupted land area. Suddenly, group of miscreants, my lord,
Mm.
from Arunachal Pradesh openly fire at the villagers of Bedati Gaon, Assam. About 11 persons severely injured and attacked, namely so-and-so, so-and-so, so-and-so. These are the names, my lord. Then one person, see Tabuk Tayang, was forcibly taken away from the place of incident to the roadside and assaulted and breaks four of his state. At present, all injured person has been admitted in the medical treatment. 7% Dhemaji Hospital, 4% Assam Medical College, so-and-so, so-and-so. Well, I belong to that particular area. Being a DSP, I has been implicated. But at that relevant point of time, I was not even that. I was posted somewhere else. I'll come to my lordship. Kindly come to page 16. I was just implicated because I belong to that particular area. This is, my lord, Bedati is the lower Siang near Dhemaji, my lord.
Mm.
Now, page 16, where I have been directed just 1 month back, my lord, on 15/7/2026 to report. I was directed in the last 3 lines, my lord, you can see, hereby directed to look after the work at CCIRBN Tikoi, so-and-so, till joining of the inspector so-and-so from Trippi to Bolang. Information so-and-so. This is a place 200 kilometers. It is a Siang, my lord. Next, my lord, that was the direction to me, my lord. Then again, on page 18, just 2 days prior to the incident, I was again directed to report with some ACRs. That you can see page 18. I was directed number DNA so-and-so, 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 IRBN officials, personnel, hereby directed to ensure that all officers and the personnel who had not yet submitted their APAR for the period from 25 to 26 shall complete their self-appraisal, submit on 10/8/2026. My lord,
Mm.
that is the date of incident also, positively including those under the rehabilitation course, those who had not yet received the APAR for self-appraisal may collect the same from the concerned APAR branch immediately. So I was directed to collect all the paper and give it to the Namsai head office by this WT message. Accordingly, next day, I was proceeded to the Namsai. Next page, my lord, page 5.
Page 19.
Hmm?
Page 19.
Page 19. Submission come forwarding duty report APAR for a period of so and so to Sikoi Namsai, Bordumsa platoon. I am the Bordumsa platoon, my lord. With reference to officer so and so, dated so and so, I hereby submit forward annual performance appraisal report, officers and personnel under Sikoi Namsai, Bordumsa platoon for a period of so and so duty reported upon further review and acceptance by the competent authority. So this is, I was the commandant. So accordingly, I proceeded, my lord, and the next page, my lord. These are the reports, my lord. Lordship kindly see page 20 onwards, and the column number 69, that is on 10th, on the date of incident, I was in Namsai, 200 kilometers probably away, and from me, they have received, my lord, point number 69, my lord, column dated 10/8/26 APR from received from DSP Nangmil so and so to so and so. So on the date of occurrence, I was in Namsai. And the page 30, I have also intimated that I am out of station and this is the incident had happened. That is subsequent, definitely, my lord. That is on 12/8/26. By this media report, I was implicated. This is the page 17. So I have intimated the superintendent of place 30, my lord, annexer 7. I have intimated the superintendent of police that some media has implicated me in the incident, but on the date of incident, I was not in the place of occurrence. Rather, I went to Namsai to submit all the papers.
Where is the media report?
Media report that I have the request for approval for transmit Polnet messages to SP Dhemaji regarding the circulation of unverified media report. Respectively, I submitted, I am presently deployed in Siang district, connection with the so-and-so district. Recent Assam Arunachal boundary incident at so-and-so certain Assam-based media houses and social media platform have been continuously circulating reports wherein my name has been mentioned and portrayed as one of the person who allegedly led the incident and opened fire at the villages. So the media has implicated me, so I have intimated the SP that I was not there. In this regard, I wish to clarify that I have visited the native village Swenso family gathering thereafter on 9. Thereafter I went to my lord, this Namsai, to submit the SCR, my lord.
Yes, Mr. Bortakur.
My lord, otherwise, my lord, yes, a very, my lord, serious incident on that day, my lord, particular day, my lord, in the border area, my lord, indiscriminate fire, my lord. Many other person, many persons were injured, my lord, and my lord, tension is still going on, my lord, in that particular area. And regarding those documents that the present petitioner was not present at that point of time in that place, my lord, in the place of incident. And thereafter, that, my lord, application submitted by the present petitioner to the, my lord, to the superintendent of police, my lord. Here, my lord, all media reports cannot be said to be, my lord, fake. But there, my lord, specific allegation on being leaded by the present petitioner, the incident happened. Now, all these facts, my lord, need to be, my lord, can be, my lord, verified only after perusal of the CD, my lord. Because, my lord, that on that day, my lord, because of that incident, my lord, indiscriminate fire, many other persons injured, my lord, many persons injured, some are, my lord, grievously injured. In my lord, treatment is still going on, my lord. So considering all these aspect, my pair before your lordship, let my lord, the CD may be verified if in fact my lord, the present petitioner was not present there, my lord. Otherwise, my lord, allegation is that from that report itself, my lord, the application filed by him that entire group was led by the present petitioner, my lord. My lord, without going through the CD, my lord, how that can be, at this point of time, it is difficult to say that he is not the person, my lord, leaded the entire incident, my lord.
That I have intimated to the superintendent, my lord, myself.
After
rather-
the incident, my lord.
Yes, after the incident, and the other report says that I was not even present. If I was present, there is no necessity more for intimating me to the superintendent that the media has come out with the allegation, my lord.
So when you will be able to produce the case there?
Your lord, any subject may be fixed, my lord. I will try to get it, my lord.
Can you produce it by tomorrow?
By tomorrow, my lord, probably it has to come from Dhemaji, my lord. 18 on Friday, my lord, 21.
Friday will be too long. Okay, on Thursday.
Thursday,
Thursday.
my lord, publish.
Item 6.
Meet please. Here, your lordship, we are challenging the judgment and order dated 10/36/2026. Six, item 6.
6 to Amina.
Wherein your lordship, maintenance amount of 10,000 was awarded against me from the date of application. My pointed ground is that I was not a earning member. I was dependent on my parents. Then
No, that cannot be a ground.
and
That cannot be a ground.
your lordship, the wife, she has been earning, and she
Mm.
has admitted that in the cross examination. And secondly, your lordship, there was an undertaking at the time of leaving the matrimonial home that your lordship, she has left the matrimonial house voluntarily under her own will, because there was no such dispute. There was only trivial issues between both of them. The primary issue was between the parents of the parents-in-law and the husband, because they were not satisfied with the marriage. So that is another ground. And third of all, your lordship will find at page 53, the quantum of maintenance which has been awarded. I'll read that para.
Mm.
Para 27,
Page number?
page 53. Internal page 20.
Paragraph number
27,
27.
last para.
Yes.
Now the important question to be decided is regarding the quantum of maintenance to which the petitioner is entitled. The opposite party is healthy and apparently an able-bodied person, inasmuch as nothing contrary has been shown to that effect. Moreover, he has the capacity to earn as he possesses good health. It is further proof that after being separated, the petitioner has engaged herself as an insurance agent. But the opposite party, despite giving many suggestions, failed to prove that the petitioner regularly earned sufficient amount of money to maintain herself as deserved by her as the wife of the opposite party. Although the opposite party claims that he has no source of income, but both his parents are government servants and pensioners, and owns vehicle and house, from which it can be assumed that the opposite party hails from a well-to-do family. As a daughter-in-law of such family, petitioner also deserves minimum standard of living, and the opposite party cannot deprive the petitioner from her entitlements. Then next para, para 29. Keeping in view the above discussion, it can be held that the opposite party has the liability to give at least 1/3 of his income to the petitioner for her maintenance. In the present day situation, minimum daily wage of unskilled labor is not less than 700. If such person works for at least 25 days in a month, he earns 17,500. In the given case, having educational qualification of 12, the opposite party even has the ability to acquire skills, and in that case, the minimum monthly income of a skilled person can be double to that of a unskilled labor. So first of all, the code determines that these skills are in regard to an unskilled labor. Then suddenly, then he also assumes the salary at 17,500 as notional. Thereafter, he says he also has the skill of a skilled labor. So how can the court hold both the things together? Can approbate and reprobate. So after assessing 17,500, the court says that I have the income to acquire more, double this income, and accordingly has awarded
No,
one
no,
third
that is only in respect of skilled labor.
skilled labor. But before that, the court has assumed that I'm an unskilled labor and has assessed the earning at 17,500. So the income should have been one third of
No,
17,000.
no, no, no. The court has not determined that you are an unskilled labor.
Yes. No.
Court simply held that
I have the
this-
capacity to be a skilled labor.
yes,
Huh.
you are class 12 passed.
12 pass. Yes.
So therefore, the court has assumed that you are
I have
able to earn
Yes.
with that of the skilled laborer.
With that of the skilled labor. But before that, the court has assessed 17,500 of
No, that is
skilled-
only in respect of unskilled labor.
unskilled labor, because skilled labor, that, as your lordship knows, requires special set of skills like carpenter, welder, electrician, etc.
Mm.
And also, as per the minimum wages act, this Assam government's notification,
Mm.
your lordship will find that high
That
skill-
notification is updated.
notification is dated 24/11/2023.
Mm.
23.
23.
24/11/23.
No, thereafter, no notification has been issued. Perhaps
Thereafter,
reviewed it was.
the updated notification, whether that's there or not. But however, your lordship will find here the highest, that is worker,
Mm.
highest skilled worker. There also they are earning 18,307. So if your lordship assumes this also to be my income, then under that circumstance, 1/4, 25% of 18,300, that comes to around 4,500. So considering that the income should be less than 10,000, at 4,500, that will be the best income that can be, best amount of maintenance that can be awarded to the wife. This is the
Okay,
notification.
let notice go at this instance. Let the record come.
Yes.
And till disposal of this petition, you continue to make payment of 50% of the order.
I'll pay that.
5,000.
Your lordship, I have already, I have taken this thing instruction, and I have calculated from 2023. If we assume the income as 4,500, it comes to around 1,50,000 till date. So half of that will be around 80,000. So I'm ready to deposit 80,000 as arrear maintenance from the date of filing of this application.
Okay, you make payment of the amount. Record.
Your lordship, this may not be executed, subject to I pay the amount. This award may not be executed. Maintenance.
Pardon?
The award, maintenance award 36/2026, that may not be executed, subject to me paying the half of the maintenance amount.
Yes.
Obliged.
Madam. In this case, there is a POCSO case mainly, and even if you want Suren Burma. And on his hand, a girl was working, and there was some assault or sexual assault, so there is the case. And on getting the cell, her mother brought back the girl.
Neither a report has been considered nor other things has been considered. A via media order has been passed saying that since their name is in the mutation mutation order, and therefore they are also entitled to get position. This kind of order has been passed. So challenging the same, we have filed a revision petition, and the revision petition passed the impugn order saying that our revision petition is dismissed only on the ground that although the Latmandal report was considered and other things has been considered because their names is there. Their names are there in the invitation order and the Zamavudi Kobiya. Therefore, they are entitled to get position. And therefore, there is no merit in the revision petition and that was dismissed. And now my, then 145 proceedings, my lord. So for the position is concerned, my lord. My lord, the executive magistrate was pleased to ask for the field verification report from the Latmandal circle officer. And circle officer has deputed Latmandal. Latmandal went to the place along with Sita and other things, my lord, and collected the evidences and all surrounding people. And they have come to know that we are having the residential houses, pakka houses are there, ponds are there, various food bearing trees are there. We are having 50 years possession, and that is the report. And on the basis of the same, merely because of their name is there in the Zamabandi Komi, in the that Zamabandi Komi, my lord will find that 91 names are there. Our name is also there, their name is also there. So here the my lord on the question of position. But so far the position is concerned, 50 years position is there in the report. And we are having our houses, electricity connection, ponds and other things. Big trees are also there. And merely because of that, my lord, their name is Jamabundi Kopi, so they are entitled to get. And in the police report also says that if the first party will go to occupy the position, then there will be dispute. It is obvious, my lord. 50 years position we are having, if the other party will come, there may be some dispute. So therefore,
Okay.
my lord.
Let notice go at this instance. We'll call for the records. Heard Mr. Sodhuri, learned senior counsel assisted by Mr. Learned counsel for the petitioner. In this petition under Article 227 of the Constitution with Section 528 of the BNSS 2023, the petitioner has challenged the judgment and order dated 29/7/2026 passed by the Learned Additional Session Judge number 3 Nogao in criminal revision number 35 within bracket N/2025. It is to be noted here that by the impugned judgment and order dated so and so, the Learned Additional District Judge Nogao on number 3 Nogao has affirmed the order dated 12/11/2025 passed in MR case number 113 of 2020 by the Learned Additional Deputy Commissioner Nogao. Peruse the petition and the documents placed on record and also peruse the impugned judgment and order dated 29/7/2026 passed in criminal revision petition number 35 N 2025 and also the judgment also the order dated 12/11/2025 passed in MR case number 113 of 2020. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by school post and also by usual process within a from today. Rest shall call for the record from the learned courts below. And list the matter after 4 weeks and pending further consideration. Operation of the impugned judgment and order dated so and so passed by the learned session judge in criminal revision number so and also the order dated 12/11/2025 passed in MR case number 113 of 2020 by the learned ADC Nogao Stance State till returnable date. Please have the
Highly blessed.
Item 40.
Wait, please, your lordship. Lordship, here petitioner number 1 is the husband and 2 is the wife. They have challenged the proceeding of child marriage, child marriage proceeding. My lord, one, I have made also respondent, my lord, of one VDP secretary, he has filed the.
Okay, let notice go.
Yes,
Let the record come.
My only prayer, my lord, this case is fixed on 20, day after tomorrow, my lord. So in the, if I have filed any petition for adjournment, that may be allowed, my lord, because on 28, the case is fixed for examination of IO. But if not state, it will be, trial will be over very soon. That is. Otherwise, all My lord, several petitions has been allowed watching the proceeding. I have also annexed.
No, allowed, that's all right, but we have to go through the record without
But
going.
my
through
lord,
the
my
record.
only prayer, my lord, on 28th, we will file an application.
No, you go and file application, where is the bar?
My lord,
Why leave of this court is required?
my lord, sometimes, my lord, adjournment may
No,
not
no,
be
no,
given.
no.
Only
How
that.
how the trial court will pass order, this court cannot direct.
My lord, otherwise, the 24 exam.
You go and file an application there, mentioning the number of the revision petition. No, this petition.
My lord. Look, my only thing, if I file, that may be allowed, that is something. My lord, because very soon trial will be over.
No, 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 that
Already
observation.
2-3 witnesses examined by PWC.
Let's just list the matter after. Correct. After 4 weeks. After 4 weeks. Step upon respondent number 2 be taken through the office of the PP, Gauhati High Court, as per notification. Notification number. Notification of the registry dated. Registry shall also call for the scanned copy of the record. List the matter after 4 weeks. Interim period of the petitioner will be considered on receipt of record from the learned trial court.
My lord, date, my lord. Date.
After 23rd September.
And-
Item 15.
15 minutes, 10 minutes of scope.
Lord, here in this case, my lord, petitioners are husband and wife, my lord. Their marriage was held in the year 2020, my lord. And at the time of marriage, my lord, the wife was 7 months short from 18 years, my lord. And they are living very happily, my lord, and a child was born out of their wedlock, my lord. In the year 2022, several, my lord, so motor case was registered by the police against the child marriage, my lord. And it is one of them, my lord. My lord, kindly see the,
Okay, let the record come, we will say.
my lord. Page
This is
16,
also joint petition.
joint petition, my lord. And they are living peacefully, my lord, as husband and wife, my lord.
Okay. Interim period will be considered on next returnable date.
My lord, in this case, my lord,
At what stage the proceeding is pending?
evidence stage, my lord.
Evidence.
Evidence stage.
Whether any witness has been examined.
No, my lord. Witness has not, only a petitioner number 1 has been examined, my lord. And my lord, kindly see her 164 statement, my lord. I have annexed the same here. my lord.
No, the problem is that at this stage we cannot appreciate the evidence.
My lord, my humble submission, what purpose will be served if prosecution?
Maybe if she refused to implicate the accused persons, then definitely the trial court will acquit him.
But that is correct, my lord. But my lord, admittedly, my lord, they are husband and wife. And it is also admitted that she was 7 months short, my lord. At
The
time of
problem
marriage.
is that the case is registered under section 6 of the POCSO Act.
My lord, 6.
Otherwise, my lord,
there are-
let them, otherwise, let them, my lord, execute a, my lord, my lord, affidavit before the, my lord, concerned court where the matter is pending, that we both, my lord, jointly wants to compromise the matter. And that affidavit may be annexed in the present petition, because case is going on before the trial court. Let them both jointly, my lord, sworn an affidavit before that court, my lord. Otherwise, in some cases, they have annexed one notarized affidavit. So it is difficult for us whether the, my lord, other party has in fact, my lord, executed that notarized affidavit or not. Let them execute, my lord, agreement before that trial court, wherein that, my lord, case is pending, that we are now living as husband and wife, and now we want to compromise that, my lord, notarized agreement executed before the trial court. My lord, that may be, my lord, annexed in the petition, if any petition filed before this honorable court. Otherwise, in everyone will file some notarized agreement that we are now living as husband and wife. We want to compromise this matter, all POSCO cases. And my lord, on that basis, in some cases, joint affidavit. And we also, although my lord, on trust, they have filed this joint affidavit. That is true, my lord. But regarding that, sometimes identity of the, my lord, victim is not, my lord, it is difficult for us, my lord, if they both appeared before, because case is going on before the trial court. So they can execute that one, my lord, affidavit at least, my lord, before that court, that we both persons appeared before this, my lord, honorable court, and here in presence of this honorable court, we have executed this agreement, although that trial court has no power to quash the proceeding. Let them, by annexing that petition, file a, my lord, case before this honorable high court. Then only, my lord, otherwise sometimes, my lord, whether the victim girl or whether informant, they have filed this petition or not, after, my lord, considerable, my lord, we are already evidence stage and everything is, my lord, everything is going on. Thereafter, my lord, they approach by stating that we want to now compromise the matter, jointly file petition, postpone there.
My lord, for a moment, page
Very
19, my
late
lord.
stage.
Kindly see page 19, my lord. 19. Statement of the victim girl, my lord. He stated.
No, but the problem is that at this stage we cannot appreciate the evidence.
Yes.
It's not permissible.
My lord, it is a matrimonial dispute, my lord, and FIR was lost by a stranger, my lord. Kindly see.
No,
who has-
in criminal case, anyone can file FIR. There is no bar.
And she, in her 164 she stated that I am living happily with my husband and we have a 3-month-old child, my lord. Now, child is 4 years old, my lord.
Better you file an affidavit there
My lord,
before the trial court.
that observation be.
No,
Otherwise-
no.
Otherwise, my lord.
Otherwise,
no,
let them
no.
come after recording the evidence of the, my lord, victim, of the informant or that, my lord, victim girl, my lord, that in her deposition also that she can say, yes, right now I want to, my lord, we are living as husband and wife, and now I want to compromise. At least, my lord, in her deposition, if they stated before.
Produce that copy of the affidavit before this court, we will see then.
Yes.
Then we have also called for the record, a scan copy of the record. If you file any such affidavit, then definitely it will come with the record. Okay. After 4 weeks. Next.
Item 16.
Ma'am, George.
Mm.
So I am before your lordship for quashing one NBW order that is 8/5/26 is, that is in page number 17, lordship.
Why you could not appear before the court?
Lordship, actually, I was out of situation for my, as my mother was suffering from English for.
But
Well,
you have
I-
engaged your counsel there?
Lordship, learned counsel of the appellant has filed one petition to represent the accused.
Where is that petition?
Your Honor, I'm added the petition, lordship, but it is reflected in the order, lordship, at the 8/5/2026.
No, you show me the petition. Page number?
Page number 17, lordship.
No,
In the order
17 is
itself,
the-
in the order itself, it is reflected, lordship, that the learned counsel filed one petition, but the said petition was rejected by the learned court below, lordship. And NBW was issued against the appellant, lordship.
Yes, it appears that on 3 consecutive dates,
Lordship,
you remain absent without stay.
Lordship, on 13/12/2025, he was present, and the same is reflected in page number 16. Kindly have a look, Lordship. Page number 16, order 13/12/2025, Lordship. It has been wrongly typed, Lordship. Accused is present. What, sorry. No, Lordship, I'm sorry, Lordship. Accused is absent. I'm sorry, Lordship. It was fixed for local other lawsuits, but the matter was not settled on that day, lawsuit. But earlier date, he was present, lawsuit.
No, you show me the application. Is it part of the record?
Lawsuit, sir. That application is filed by the learned counsel of the appellant, not annexed here with lawsuit.
Is the copy available with you?
Lawsuit,
Not available.
available lawsuit, just 5 minutes,
5 minutes. Okay. After some time.
lawsuit.
Item 46.
Your lordship may take up item number 47 first. Both are arising out of same FIR, my lord. Company. My lord, before referring to the documents, my lord, GST Act, my lord, is a special act, your lordship. And in GST Act, your lordship, in GST Act, my lord, if the amount involved is, my lord, less than 5 crore, under the Act, my lord, it is bailable and non-cognizable. I will refer my lord documents. My lord. Here, your lordship, I am seeking, my lord, quashing of FIR, stay, my lord, in the meantime, stay, and my lord, regular bail also. That I will place, my lord, decision of, and this honorable court is passing order in criminal petition also.
Bail is also granted.
Granted, I will place my lord. In case of Arnav Goswami case, what has happened, Bombay High Court in quashing petition said that you go and file 439 application and notice was issued. Against that, appeal was preferred before Honorable Apex Court. Apex Court says because 482 empowers the court as an inherent court, and in that case, since the prayer was there for granting bail, regular bail, in that case, so bail ought to have been granted by High Court.
No, subject to the condition that there is extraordinary situation.
I will place, my lord. There is extraordinary. Here the case, and on the basis of that, this honorable court, my lord, in a number of decisions, I have given compilation, passed and released the petitioner on bail as an entry in writ petition as well as in, my lord, criminal petition, in both. In GST matter. Just, my lord, I recapitulate, my lord, what I want to place. If the amount involved is less than 5 crore, your lordship, then under the GST Act, it is bailable and non-cognizable. If it is above 5 crore, then it is, my lord, non-bailable and, my lord, cognizable.
What is the amount involved in this?
Here,
matter?
12 crore, my lord.
12 crore.
I am coming on it. There cannot be second FIR on that. So on the basis of that, GST department initiated proceeding under section 132 of the GST Act. That, my lord, will find at page 41, my lord.
Yes.
And here your lordship will see para 3, page 42. That based on actionable intelligence and system-based data analysis from GST and e-way bill portals, a large-scale racket involving fraudulent availment of input tax credit. My lord, input tax credit is, my lord, like that I have raised fake invoices and taken, my lord, input tax credit. And the person who has issued fake invoices, my lord, he has not deposited his tax amount with the government. So it amounts to, my lord, taking wrongful availment of ITC, input tax credit. Thereafter, my lord, that preliminary investigation and analysis have revealed that Sri so-and-so has knowingly and willfully availed fraudulent ITC from non-existing and bogus taxpayer involving a total amount of 12 crore 10,76,251 so-and-so, thereby causing substantial loss to the government's tax checker, indicating deliberate tax evasion. So, my lord, this is the allegation, basically. So, investigation in respect of this, my lord, under GST Act was going on. What they have done, my lord, interestingly, page 49, same department, and relevant page, my lord, page 52, and I am taking your lordship, page 53. This is the FIR given by tax department through a special task force in respect of the allegation which they are already investigating. May I read your lordship? During the course of investigation conducted, it is written by tax department, my lord. Under Assam Goods and Service Act, it has been revealed that the above mentioned taxpayer in connivance with other accused persons prudently availed ITC so-and-so from 4 non-existing fictitious firm without any actual supply or receipt of goods so-and-so, so-and-so. So same allegation is there, my lord, regarding 12 crore something. And at the bottom, what they are writing, my lord, why they have lost this FIR? although, very interesting, my lord, at the bottom, my lord, although they are admitting that, although the state GST department has initiated proceedings under the relevant provisions of the GST law, the scope of investigation required to unearth the entire criminal conspiracy, identify all associate persons, entities, trace the complete money trail, and establish the role of beneficiary extends beyond departmental jurisdiction and resources. So on that ground, they lodged this FIR to STF, saying that although we are doing the investigation under the GST Act, but since we are not well equipped, so please you also investigate the matter. Number one, my lord, when the special act has been enacted for the purpose of, my lord, carry out the allegations in respect of, my lord, ITC, fraudulent ITC section 74, my lord. In that case, my lord, in my humble submission, my lord, STF have no jurisdiction to step in and initiate, my lord, parallel investigation. Number one, your lordship. Number two, your lordship, will kindly see, when, my lord, person, we are saying, my lord, it is assuming, my lord, 5 crore, 10 crore, 12 crore, whatever the amount. But on what basis they came to that amount? It has to be determined under section 74 of the AGST Act. I will place my decision of Honorable Supreme Court also. Without determining the amount involved in the case, no one can say that this amount has been, my lord, evaded, this amount was misappropriated. For that purpose, my lord, section 74 has specifically made, and for that penalty and other provisions are there. The best recourse would be, my lord, that you first determine the amount involved in the case, then you refer the matter for prosecution to the GST department itself. But, my lord, initiating parallel proceeding on the same subject matter, as per, my lord, TT Anthony, that judgment also, my lord, is not permissible under the eye of law. My lord, now I am just placing some decisions, my lord. In fact, my lord, in the similar situated condition, page 85, my lord.
No. Whether TT Anthony's ratio will applicable here?
Applicable.
How?
Because, my lord, tax department is investigating the matter under section 132 of
No,
GST.
they have not registered any FIR.
Right, this is the, my lord, I have shown you.
Which one? No,
Page-
this is the FIR they have lodged with the STF.
This FIR and their FIR, page 41. The investigation which they are carried out. That I have read, my lord, para 3-4. This is the FIR. Before the Kamrup chief, so-and-so, it is represented by Manoj Dev, Superintendent of State Tax. It is given by state authority. And Rishikesh Kalita, they have arrested this Rishikesh Kalita also. Tax department. And para 3 and 4, my lord, can you see, this is the allegation, same allegation, my lord. And in the STF FIR, your lordship will find, I have read, my lord, just now.
No. Whether any case has been registered on this?
Yes, my lord. Case number, my lord, CTENF ARST 2016-2007 at the top, my lord. And in an application under section 132(5) of the so-and-so. This is a case, my lord. They are investigating the matter. They arrested this Rishikesh Kalita. He is behind the bar, my lord, by the tax authority. During the pendency of this investigation, they lodged this FIR to STF, saying that they admitting this. Page 53, my lord, can you see at the bottom? They are admitting we are investigating. Page 53 at the bottom, although the state GST department has initiated proceedings under the relevant provisions of the GST law, the scope
whether this amounts to FIR?
which
This one,
yes, my lord,
this proceeding.
complaint petition, my lord, they on the basis of these, they can arrest under section 69 of the AGST Act. They have arrested this Rishikesh Kalita. He is still in judicial custody, my lord. So it is FIR. Power panel provision has been given under the special act. And that, considering that aspect, my lord, this honorable court, page, my lord, kindly see 85. When BIO registered case in respect of, my lord, AGST provision, this honorable court, after hearing that special act and all. And the judgment relied, which I am going to rely, my lord, special act prevail over general law. Stay the proceeding, my lord. Page 86, my lord, kindly see, Mr. So-and-so, that case ought to have been investigated, a person authorized by the commissioner of AGST, not by the police officer. As such, the registration of FIR against the petitioner is illegal and not tenable, and therefore it is considered allow the petition. So-and-so other cases are also pending, my lord. Having regard was, I have carefully thorough the instructional documents placed on record, and on perusal of Assam goods and service taxation, so-and-so, the decision in silver drop that I will place, my lord. So-and-so. However, after hearing the submission of both the sides, it is provided and notice return so-and-so. Thereafter, till return, the further proceeding was stayed by this honorable court. In that case, tax department had not registered, they have given to BIO in this case. But here, my lord, tax department is also investigating the matter, and they have given to STF to or investigate the matter. Twice, my lord, parallel proceeding is going on. Regarding determination of tax and whether the bill should be granted in, my lord, criminal petition order, that I have given compilation, my lord, kindly see compilation. I will not bother your lordship, 2 or 3 paragraphs, my lord. These matters are still pending, my lord. I appeared in this matter. Page 1, my lord, kindly see. Take compilation of that. This is the criminal petition filed before Kohima bench of this honorable court. And after hearing, my lord, this honorable court enlarged the petition. He was in judicial custody on bail. Matter is still pending. Second, my lord, page 5. Page 5, my lord, kindly come. And page 13, my lord, can you see regarding power for under 482, para 14, page 13.
Page number?
14, page, it start from 5. Criminal petition, my lord, Varun Goel, where my learned friend appeared, my lord. Mr. Gogoi appeared, my lord. I am taking your lordship to page 13, para 14, regarding power, whether this court can grant or not. Mr. So-and-so, may I read your lordship, 14, 1-4. Page 30. Mr. So-and-so submitted that prayer for bail can be considered in the petition filed under section so-and-so. And in that context, he has relied on a decision of Honorable Apex Court, passed in so-and-so, relevant paragraph was quoted. And ultimately, my lord, page 220, my lord, interim bail was granted by this honorable court. Now, my lord, kindly see Arnav Goswami case, where Apex Court says in 482, if the petitioner is praying for interim bail, it should have been granted, your lordship. Page. I'm coming, my lord. Para 41, page 52. Bottom, my lord, jurisdiction of the High Court, you all have got it, 52, right hand side, my lord, bottom. My lord.
This decision is of 2 judge bench decision. There is another decision of 3 judge bench.
My lord, this after Arnav Goswami.
No, before that. The Niharika infrastructure.
Niharika was the, my lord, in respect of, may I submit, my lord, whether while granting, my lord, while issuing notice under 482, whether the court can say police not to arrest, that was prohibited in Niharika case. Here, my lord, Niharika case was also delivered by my lord Justice Chandrachud, your lordship. And here, my lord, kindly see jurisdiction of the High Court under Article 226 of the Constitution and Section 482 of CR.
No, that is there. But what extraordinary circumstances here in your
my
case?
Lord, extraordinary circumstances is this, my lord.
Why you could not approach the criminal court?
My lord, when I am here, the person who is investigating the matter.
Why?
My lord, there is no answer to why. But the answer of your lordship's extraordinary situation is this. The person who is investigating the matter, he has no jurisdiction. The person who has
No,
not,
maybe that may be a ground for staying the proceeding.
My
But where is the ground for granting you bail by this court?
because my lord, the person who has no jurisdiction, who arrested me, directly hit Article 21, your lordship.
Mm.
In that case, your lordship is certain. That's why Apex Court,
Mm.
while dealing with that, life and liberty and all, said that when the proceeding was, my lord, stayed,
Mm.
finding that it was, in that case, only notice was issued.
Mm.
Honorable Apex Court granted bail, in SLP granted, directly granted bail. That my lord will kindly see page 7, page 66. Page 65, 74. 70, page 70, my lord, kindly see. Para 74, page 70. Conclusion. May I read, my lord?
Para 70.
So page 70,
Mm.
70, and paragraph 74.
Mm.
May I read, your lordship?
Mm.
While reserving the judgment at the conclusion of arguments, this court had directed the release of all the 3 appellants on bail, pending and disposal of the proceeding before the High Court. The following operative directions were issued. Interim, my lord. We are of the considered view that the High Court was in error in rejecting the application for grant of interim bail. We accordingly order and direct that so and so release on bail. Before that, my lord, certain guidelines were given why the bail should be granted. When it hits my lord personal liberty and all, I was arrested on 1st of August, your lordship. I'm languishing in bail from last 15 days, your lordship, by the person who has, in my humble submission, my lord, subject to what my lord would say, has no jurisdiction. Number one, without determination, tax authority is the, my lord, competent court, a competent authority to determine the, my lord, amount involved. And my lord, STF cannot trench upon a power which is specifically reserved for my lord, tax authority. In Amitabh Bachchan case, your lordship has known, my lord, Honorable Apex Court held that if the power has been given to different authority, one authority cannot trench upon a power given to another authority. Since the special act has been enacted, dealing with the situation as incorporated in the present case by the GST authority, and GST authority has already initiated the proceeding by lodging, in that case, my lord, lodging FIR before STF, in my humble submission, my lord, nothing but to harass me, my lord, without jurisdiction, and it is liable to be set aside. At this stage, my lord, I will request your lordship that proceeding may be stayed, my lord. And in the meantime, my lord, I may be allowed to go on bail, my lord. I have placed, my lord, decisions of that criminal petition, Arnav Goswami, and this honorable court is granting bail in criminal petition. If your lordship want to see whether the determination is mandatory or not, that, my lord, will see in the Punjab and Haryana judgment, my lord, page 188. It starts from 188.
Mm.
Para 8, page 190. In Delhi High Court, in respect of service tax, my lord, may I submit, your lordship? Then it would be easier, your lordship. In Delhi High Court, in respect of service tax matter, one person was arrested, my lord. Delhi High Court came to the conclusion that without determination of tax liability, you cannot say that this is the amount involved in the present case. And he was enlarged on bail. Against that, my lord, union preferred appeal before Honorable Apex Court. And Apex Court had upheld the judgment passed by Delhi High Court. On the basis of that, my lord, page 195, kindly come. 195, para 11, and internal paragraph 38, 3A, in respect of GST, my lord. Thus, it starts from thus. May I read, your lordship? Thus, determination of excess credit by way of the procedure set out in section 73 or 74, as the case may be, is a prerequisite for recovery thereof. Section so and so deal with assessments, and as such, it is clear and unambiguous that such recovery can only be initiated once the amount of excess credit has been quantified and determined in an assessment when recovery is made subject to determination in an assessment, the argument of department that punishment for the offense alleged can be imposed up even prior to such assessment is clearly incorrect, amounts to putting the cart before the horse. This was upheld by Honorable Apex Court that I have annexed, my lord. In addition to that, my lord, they arrested under section on the FIR registered before them. My lord, if the punishment is less than 7 years, my lord, notice under section 35(3) is mandatory, your lordship, as per Ernest Kumar, your lordship.
No,
Without-
whether that notice was not served. upon-
Not, sir. That ground I have taken, my lord. Not, sir. And if the notice has not been given and I have been arrested, then in that case, as per Satyendra until, my lord, that judgment I have given in compilation, para 103, I am entitled to bail. Page, my lord, kindly come to 360.
No, that is there. There is no doubt about it. But
And
the
regarding
question
my
is,
lord,
why
state-
don't you approach the?
Proof, when I am approaching this honorable court, I don't want to burden this honorable court by filing another application. If your lordships feels that I should go and file regular bail application, will file. But here I have tried to, my lord, make out a case where the authority.
No. Some observation is there in the decision of Niharika case that if the other remedies are available, instead of granting bail by exercising the power under section under Article 226 and section 482, the court should relegate the parties to avail the remedy.
My lord,
That is the observation.
my lord, relying that judgment are also in my, Niharika judgment are also referred.
Niharika is a three-judge bench decision. This Manoranjan, this
Two judge.
Goswami will not help you.
My lord. So in that case, at this stage, my lord, I would pray, my lord, your lordship may issue at this stage and further proceeding, my lord, may kindly be stated.
Okay, yes, Mr. Gogoi.
So far as the interim prayer is concerned regarding, my lord, staying the further proceeding of the investigation is concerned, my lord. There, my lord, I will like to file my objection, my lord. Lordship will hear it any day after, my lord, 7 days. Let me, my lord, make my objection in this regard. Now, there are some allegation that, my lord, there are two parallel proceedings on the same offense. That is his case. And, my lord, second ground is that, my lord, the GST authorities have only taken up the issue as per the provisions prescribed in the GST Act, whereby a person can be arrested. In fact, my lord, the petitioner, one of the accused has been arrested, as well as the present petitioner. Under the proceeding, my lord, where he says that it is a complaint case, it has been annexed. Now he is playing that, my lord, he should be granted bail, my lord, in a proceeding where he has challenged the STF, my lord, police case. That case that has been registered by the STF. So that probably, my lord, will not come in, my lord, in the present case, because he will have to, my lord, pray for a bail in that particular case where he has been arrested, not in this particular case.
I am praying in that case.
Regarding, my lord, the quashing of the FIR before the STF, my lord, that I will file my objection. Today, my lord, at this stage, 12 crores, my lord, they have fraudulently, my lord, availed the input tax credit, thereby causing huge loss to the state exchequer. There is nothing to show that, my lord, that particular firm or the dealer with whom, my lord, they dealt with, that was the existing firm. There is nothing on record. So apparently, their offense, my lord, is, my lord, writ large in the present proceeding, my lord, I would say, is apparently. So regarding the technical part of the legal issue, whether we can have two parallel proceedings, that, my lord, I will find my objection to that. Then lordship will consider that part, my lord, whether the proceedings should be stayed or not, only after my objection, my lord. Written objection I will file. Let it be, my lord, in next week, any day convenient, my lord. In both the cases.
Monday next.
My lord, so far as, my lord, here
For
I am.
consideration of your interim pair.
Yes.
For staying the
But so far as,
proceeding.
my lord, item number 46, my lord,
Yeah.
no corrective measure may be taken against me till then, my lord.
My lord, that, my
My
lord,
lord, till then, my lord,
may
this is
not
a
be
case of
considered
stay.
on the next.
What I am saying, so far as I am concerned, no corrective measure, my lord. Not more than that, my lord. This is case of granting stay, my lord. But since my learned friend is praying that he will file, so far as this matter is concerned, where I am behind the bars, I will file regular bail, my lord. So far as another case, my lord, I am outside, my lord.
My lord,
So
item
no
46.
corrective measure till then. In other case, I have been protected by this honorable court by in GST case that I have annexed, my lord.
Yes.
I
That, my
have
lord,
been
he can
protected.
avail, my lord, by Filing a proper bail application, my lord. He has already moved it before the honorable court.
Then in that case, your lordship may stay the proceeding, my lord. If my lord,
There-
my learned friend is
My lord,
insisting
in both the
upon.
case, I will file my objection. He has
He
challenged
may
the.
file, he may file, my lord. Till then, if your lordship is satisfied that the FIR registered by STA prima facie, my lord. In that case, if my learned friend is in a position to show that, in that case, your lordship may vacate that stay
No, no.
on that day.
Let it be on Monday or
Why,
Tuesday.
my-
Can
my
it be
lord?
on Tuesday, my lord?
Well,
25th.
at least, my lord, some
Instead of
that
Monday.
in 46, my lord, no coercive measure.
Okay, we'll see.
My-
We'll examine and pass the order.
My
Okay.
On
So
25th,
we'll list the both the matter on Tuesday then.
Tuesday.
Tuesday, date. In that, my lord, because I have to file bail, so liberty may be given to file.
No, we'll see. We'll examine the
My-
matter. Okay. Hard. Mr. Your name, please?
A Rahman.
Learned counsel for the petitioner and Mr. Bartakur, learned counsel for the petitioner. In this petition under Article 220, no, under Section 528 of the DNSS 2023, the petitioner has applied for causing and setting aside the order dated 8/5/2025 and all subsequent orders. Passed by the learned additional Chief Judicial Magistrate Kasar Silsor in NI Trinbakashire case number 289 of 2024. It is to be noted here that by the impugn order dated 8/5/2026 and subsequent orders, the learned Chief Judicial Magistrate, additional Chief Judicial Magistrate Kasar Silsor has issued non-bailable warrant of arrest against the present petition for default. Learned counsel for the petitioner submits that on account of illness of the mother of the petitioner could not appear before the learned trial court, and accordingly he has instructed his counsel to file an application before the learned trial court. But the learned trial court, by the impugn order dated 8/5/2026, has dismissed the said application and thereafter directed to issue non-bailable warrant of arrest against him. Learned counsel for the petitioner further submits that the petitioner is ready to face trial and will appear before the learned trial court on each and every day, and therefore he is contended to set aside the impugn order dated so and so, and also all subsequent orders, if any, by which a non-bailable warrant of arrest is issued against the present petition. Mr. Bortakur, what is your stand?
Yes, my lord, let him appear.
Mr. Bortakur, learned additional PP for the state respondent submits that the accused may be directed to appear before the learned trial court. Whereas, having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents flashed on a record, and also perused the impugn order dated so and so since. Whereas, taking note of the submission of learned counsel for both the parties and also considering the ground assigned by the learned counsel for the petitioner for failing to appear before the learned trial court by the petitioner on 8/5/2020, 8/5/2026. This court is inclined to dispose of this petition by directing the petitioner to appear before the learned trial court. When the next date is fixed,
13th of October.
on or before
10th September.
10th September, and to file an application for allowing him to remain on previous bail or to grant him fresh bail. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till then, the impugn order dated. No, till then, the non-bailable warrant of arrest issued against the present petitioner shall be kept in abeyance. Non-bailable warrant of arrest issued against the petitioner by the impugn order dated so and so, and by subsequent orders shall be kept in abeyance.
Developed, Mr.
Items for bail hearings. Item 23.
This number it has.
Charges are applicable.
Right. CDO's call for lordship. Lordship. I approve the trial court lordship to take direction to consider my bail application. Pardon, Minister, and learned counsel for the petitioner. Mr. Goswami for the respondent number 1, Dr. Pooja Agarwal. You are legal aid counsel here?
Legal aid counsel.
Legal aid counsel for the respondent number 2. This application under section 483 of the BNSS 2023 is prepared by accused Soyo Dale, who has been languishing in jail asset in connection with Kosovo PS case number 10 of 2026 under section 87 of BNS 2023, edit section 6 of the POCSO Act. Mr. Goswami, learned counsel for the learned additional PP submits that though he was directed to produce the case diary before this court, yet as per his information, as per his instruction, the IO has completed investigation and submitted charge sheet being charge sheet number
9/26 dated 26/6/26.
before the learned trial court. Then as such, he could not produce the case diary before this court hearing. Mr. Ahmed, learned counsel for the petitioner, submits that since charge sheet has been submitted in this matter, the petitioner will approach the learned trial court. And as such, this petition may be disposed of. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition, granting liberty to the petitioner to approach the learned trial court by filing regular bail application, and in the event of filing such an application, the trial court shall consider the same in accordance with law.
24.
24 of service reported awaited. We have communicated lordship, but we have not received any instruction regarding service of notice. Pray for a short date, lordship will try to produce that service report. Lordship.
From which PS?
From Jaludbari.
Third, Mr. Rabha, learned counsel for the petitioner, Mr. Goswami, learned additional proof for the state respondent. Mr. Goswami submits that he has not received the service report from the officer in charge jurisdictional PS. Accordingly, Mr. Goswami is directed to produce the service report before this court on day after tomorrow. Day after tomorrow.
20 of August. Item 25.
Yes.
Steps.
My lord, this is a POCSO, my lord. And the accused is, my lord, in jail since 2/5/2026, my lord, more than 110 days, my lord.
Probably lordship steps to not.
We had the bar. My lord, we have taken steps for service of notice to the informant, my lord. Because as per the rules, my lord, informant has to be heard. While considering the bail application.
No, when
My lord,
when did you take step upon the respondent number 2?
yes, my lord, we have taken steps on 5th of August.
No steps have been taken.
My lord, I have copy of that,
For registry.
Lordship, on 5th August.
5th of August.
On 5th August, we have taken.
5th of
What?
August we have taken.
On 5th August. Well, it is showing in the system.
No, that's all right. Then why?
Lordship, I have to take the instruction regarding that, lordship, but whether we have received the
Office code, I have to check the registry. Milord, fifth of August, yes, I have the copy, Milord.
You have taken a step as per the notification of the.
Correct, as per the notification, Milord. So
You
apply
obtain
postal
instruction at 2 p.m.
Lordship.
At 2 p.m. Let him obtain instruction.
26.
26 Lordship, service completed. Service completed, Lordship.
May be pleases you, Lordship. Service completed, your Lordship.
And I'm at the company.
And this is also POCSO matter.
Lordship.
POCSO matter, your Lordship, but the length of detention is here, your Lordship, 2 years, more than 2 years.
Okay, today we will engage amicus
Yes, sir.
for the respondent number 2. Our Mr. Das, learned legal aid counsel for the petitioner, and Mr. Goswami for the state respondent. Mr. Goswami apprised this court that as per his instruction, service upon respondent number 2 is completed, but no one entered appearance for the respondent number 2. Accordingly, Kabir. Twenty-nine. Dillu nage. Boy to Zoya Mani. Accordingly, Sri Boydur Zoyamani Deka is appointed. B Deka. Okay. Is appointed as amicus to represent the respondent number 2. This is reflect the name of the amicus in the cause list and also furnish the relevant papers to him well in advance and list the matter on
Thursday, Thursday.
26th. On 26th.
Thursday may not be possible because
On 25th.
20 Monday,
Monday.
Monday.
Tuesday, your Lordship.
Tuesday.
Tuesday.
Okay.
I'm
25th.
deeply obliged.
27.
May I please, Your Lordship?
Yes.
Today is 62 days, Lordship. I'm a driver by profession, Lordship. And so far as concerned the seizure list, Lordship, page number 24.
As there is available.
there
at the
is, my
bottom.
lord.
Okay.
Case is registered under my lord UAPA Act, my lord, 10 and 13 of the UAPA Act is also there, my lord. And extortion 3082, my lord.
Yes.
Kindly, there is a page number 24, Lordship, the seizure list.
Yes.
Lordship, so far concerned the seizure list, no extortion calls made from my part, Lordship. Here, it is prepared on 18/6/2026 at 11:58 AM. And IMEI numbers of the mobile handset seized from the accused person are mentioned here. But in the FIR, page number 10, Lordship, the FIR was registered on the same day, 18/6/26, but after almost 1 hour from preparing the seizure list. From preparing the seizure list, Lordship. But in FIR as well as a forwarding, no IMEI number was mentioned.
Is it a ground for granting you bail?
Lordship, as per
The mobile number, IMEI number of your mobile is not mentioned in the FIR?
Lordship, it may, because Lordship, in the FIR, the phone number they have mentioned, and they've stated in the FIR that the IMEI number of the missing person, namely Lambit Gogoi, was used by the phone number they have mentioned in the FIR 9612068032, used for the extortion call, your lordship. But the phone seized from my possession, the phone number is different, lordship. So I'm arrested only on mere suspicion, lordship.
Okay, yes, Bortakur.
Yes,
is there
case
any
diary received,
material?
from the case diary, there are sufficient materials against the accused person, and regarding the phone number she has pointed out, my lord, I would like to point out, my lord. Initially, one, my lord, missing report, one Lambit Gogoi, one person was, my lord, during one missing report was there, information received that he was missing since 7/6/26. And his mobile number was, my lord, that is reflected in the first paragraph of the FIR. And thereafter, my lord, during investigation, my lord, one, my lord, extortion call was received by one of the person, namely Praveen Sunwal, my lord. He, my lord, specifically mentioned one phone number that is also specifically mentioned in the FIR, that is, my lord, 9612. His statement is available, 9612068032. And later on, my lord, someone demanded through WhatsApp call from that number an amount of rupees 5 lakhs. And thereafter, my lord, during investigation, the present accused person was arrested, and from that accused person, that mobile number, although, my lord, what he has done, he has, my lord, after removing the SIM card of Lambit Gogoi, my lord, a new SIM card was inserted, and new SIM card number is, that is, my lord, 9612068032. That was used for extortion call, my lord. And, my lord, that mobile phone was, my lord, along with that IMEI number, that is in fact of the, my lord, Lambit Gogoi, who initially, my lord, later on, my lord, during investigation, there are also that Lambit Gogoi was later on, my lord, on being facilitated by the accused person, joined in the ban organization, that is Alpha, my lord. And, my lord, during thereafter, my lord, my lord, CBR analysis, and there are lots of some other accused persons were also arrested, and how this accused, the present petitioner, my lord, involved in, my lord, procuring various SIM cards from various districts of, my lord, Mon, Nagaland, my lord. And thereafter, those SIM cards were, my lord, supplied to the ban organization. Thereafter, my lord, from that mobile numbers, extortion call was made. Regarding that, my lord, there are sufficient materials against the present petitioner, and, my lord, thereafter, some other accused persons, my lord, from their statement is also available, my lord.
Okay,
Before-
Bortakur, you produce the case diary to the court master, we'll see.
Yes.
May I please, lordship?
So my prayer before lordship, at this stage, my lord, my lord, investigation is still going on. So he is, my lord, actively involved in this, my lord, in this bed for.
Yes.
Lordship, the case is based only on the extortion call, the phone numbers and the IMEI numbers, lordship. The seizure list was prepared on before noon, lordship, on the same day, but the FIR was registered after 1.5 hour, lordship. But they have not mentioned the IMEI number in the FIR as well as the forwarding, lordship. So there may be a very chance of doubt, lordship. There may be very chance of modification, lordship.
Okay, we'll see what materials are there in the case diary.
Yes, ma'am. As per my instruction, my lord.
My humble submission is that, lordship, I am a only earning person of my family, lordship, and I am a driver by profession, lordship. If further
we'll see.
detention may hamper my profession, lordship.
And as per my instruction, my lord, on the basis of, from all these collecting, my lord, phone numbers, extortion call is going on in various, my lord, in the.
Okay, next set.
Deeply obliged.
My lord, here, as per office note dated 14/8/26, my lord, service report awaited, my lord, in this case.
Heard Mr. Mazumdar, learned counsel for the accused. Mr. Bortakur, learned additional PP for the status. Mr. Bortakur submits that service report, comma, as per office note dated 14/8/2026 is awaited. Let's the matter. You have taken a step to the office
Taken
of the
step.
PP.
On 11th, I will.
11.
Yes,
11. Whatever you obtain instruction,
Yes, my lord.
SSL list it on Thursday.
Yes, my lord.
And on that day, Mr. Bortego shall obtain instruction from the officer inserts jurisdictional PS in respect of service of notice upon the respondent number 2. Thursday.
Obliged.
Correct.
30. Item 30.
None appears for the applicant on call, lays the matter after a week. In the event of subsequent non-representation, appropriate orders will follow.
Item 32.
Bortacru case they received.
No, my lord, I have received the instruction regarding filing of search sheet, my lord. Item number 30, my lord. 30, 30.
Search sheet submitted.
Yes, item number 30, my lord.
What is the
Search sheet number 36/26, dated 28/4/26.
under section?
Well, section not mentioned here, my lord. Only the. Well, item number 30, my lord. Security.
Search sheet number
36/26, dated 28/4/26.
of Doboka PS?
Yes, ma'am. Doboka PS 198/24.
Okay then. We'll close this petition,
Yeah.
granting liberty to the applicant to approach the trial court.
Item 32.
May kindly see my annexure 1 million, there is a Azhar million, page 9. And Vanigala is also there, million, that is offense. Page 14, type. Married. Million. I'm the mother of Miss English Sanu, resident of village Swanso, district Swanso. My mother was alone at my home. Actually, my daughter was alone at my home on daughter Swanso at around 7 p.m. and the accused person, namely L. Birala Singh, Ibrahim Miller, came to my home and tried to attempt to rape and forced my daughter to attempt to get raped by the animal behavior. And realizing my daughter is only 15 years old. He is a mass frightened and mentally shocked. One who even tried to do suicide. The patient as the burial in her blood relation uncle. Actually, what happened, Millard, both the families are Millard neighbors. Boundary is same. There is some dispute of land also, Millard, and the person of lordship petitioner, he is Millard a social worker and involved with the social activities. I have mentioned paragraph 3. And he sometimes Millard administer her. That means some minimum Millard that the questions to read his books as her books, etc. So Millard, the police received the Azhar and register the case under section 6. 6 is not involved here, Miller. Only Miller, my submission is 6 is not involved. It either it comes under section.
No, the victim is.
Please, Lord. I can take this matter along with item number 48, my lord.
48.
48. Well, same petitioner, my lord. One, I have filed for criminal petition for passing of an order, proclamation and attachment, and one is for anticipatory bail application. Same petitioner. Lordship, and earlier did, my lord, LCR has been called for. The same has not been received as per the office note, my lord. My lord has passed an interim order in item number 48, my lord. The impugn order has been stayed till returnable date, my lord. The date may be extended, my lord.
Or Mr. Holloway, learned counsel for the petitioner, and Mr. Bordhaker, learned additional counsel for the state respondent. Office note dated 17/8/2026 indicates that the TCR has not yet been received. Accordingly, it is provided that rest shall list the matter. The rest shall issue urgent reminder to the learned trial court for transmitting the scanned copy of the record. And list the matter on
27 August.
till then interim order pass order shall continue. In AB, what to do?
My lord, the LCR has been called for, my lord, that has been not received.
In AB 1739 of 2026, Art Mr. Holloway, learned counsel for the applicant, and Mr. Bordhaker, learned additional counsel for the state respondent. Office note dated 17/8/2026 indicates that scanned copy of the TCR has not yet been received. Rest shall issue urgent reminder to the learned trial court for transferring the scanned copy of the record, and shall list this application along with criminal petition number 1055 of 2026 on
27 August.
27 August.
My lord, I'm making mention on behalf out of turn, my lord. Item number 30, my lord. I was on
That
lagging.
matter, Sarsit has been submitted.
I'm on entry, my lord. I'm on entry in this case, my lord. In the space of someone, I will be protected.
Yeah, one date. Date of the delivery. No, এটা কব লাগিব ন ডেটটো তাতে
Yes, it can.
10th of September. You go and appear, apply for regular bail.
After my entry was granted by the Honorable Court, I appeared twice. Since they took at me the signature in white paper, they are not said go and come later. Again, my lord, when I went to my police station, again they took signature in the white paper, but they did not record my statement.
That's all right. Till next day, we will extend your prayer.
Items for admission. Item 17.
Yes.
Lordship, it was heard in part. One of my colleagues had done the matter on earlier occasion.
Yes.
Today I have gone through it, your lordship. There are judgments here and there, your lordship. Some are in favor of them. And some says like in some cases we have found, my lord, sentence has been reduced, my lord. Punishment has been reduced. Honorable Supreme Court Justice. That video soon.
No, here both the parties are married.
Yes.
Lordship.
Subsequently, they have arrived at settlement
Yes.
by way of mutual divorce. Now, lordship, whether 376 provision was the charge sheet was filed against him. So that's
No,
376.
whether that provision will be
non-compoundable.
applicable because they are husband and wife.
Lordship.
There's a marriage certificate is annexure number 3.
My lord. Let's check that. Is
number 31.
31 marriage, yes. Date took it as also.
June 5th, June
June 6, 2017.
Oh,
And charge sheet was filed, my lord. Charge sheet is 18.
After 3 years marriage.
9/6/19 months. Charge sheet. Even a marital rape is also committed, Your Lordship. There are the punishable offense.
This certificate is of dated
17, my lord.
June 6, 2017.
Yes,
Then FIR was lost in the year 2019.
yes.
So by that time, they are married person. How this cert will be applicable? And now they have settled the matter.
Settled the
Yes.
matter. Also, decree of divorce has been granted by the Honorable Family Court, and both are married to different spouse now. They are married happily. By manipulating records, she was selected.
No, no. This is entirely, she was not selected. She was not selected. Later on, in another recruitment process in 2025, which was initiated, and she was selected in 2025. And this case relates to the recruitment process initiated in 2021. So it has nothing to do. And there is no role. There are other candidates were also in that same event of running. They were not accused. She made accused. No materials, no specific allegation against her. Only thing is that her phone number appeared in the CDR of another accused. This is the only material.
Okay, on Friday?
On Monday or Tuesday, Tuesday. Tuesday. He has
Then
paid for some
let it
time.
be in the
Because now he-
second week of September.
Yes, my lord. Otherwise,
But the problem is that the lady was selected.
Yes. Then she is not allowed to.
She could not join because of the pandemic.
She is not allowed to undergo the training. That is the.
in this case, my lord, she was not. Later on, my lord, during some, my lord, she has again appeared for the selection process, my lord. My lord, this is the selection process of 2021.
No, because of this case, she was not allowed to join.
Yes, my lord.
And that's why it is urgent.
Try it on Friday.
Friday, yes, my lord. Friday, if otherwise, my lord, because only he has to provide me the verbal instruction. Otherwise, some according to him, my lord, some, my lord, because now he is posted in some other place, so he has to go through the records. According to him, my lord, there's some circumstantial on the basis of direct material, that is 161 statement, that is not there. But so because of some technical issue, my lord, some technical issue is there, and my lord, my lord, along with some my lord, other home guards, my lord, probably it was required to, my lord, take my lord, fifth round.
No, what it says, the proceeding is pending.
My lord.
Charge case, sir.
Yes, charge has been framed. And
no, whether those technical matters are part of the charge sheet.
Technical details are there. That is, my lord, in the record, but from that record, it is difficult for me to ascertain, my lord, regarding some CCTV footage, and thereafter server some records where, my lord, they are, and from the records of the CCTV footage and those, my lord, they are in the server. There is some
there are statement recorded under section
manipulation
161 about the CCTV footage.
manipulation of records, my lord. That is, my lord.
No, if none of the witnesses examined by the IO implicated her, how can you establish the charge against her during
there is no
trial?
implication of her.
That is some technical issue, some at that point of time,
And
because
without
physical
material, my
efficiency
lord,
case,
without
one-
material, any material and any specific allegation, it would be abuse of the process, and she is being highly prejudiced.
Let it be on Friday.
Friday.
Friday. Heard Mr. Loskar, Learned Counsel for the petitioner, Mr. Borthakur, Learned Additional for the respondent. This is a list the matter on Friday. As parted. And in the meantime, Mr. Borthakur will obtain the relevant instructions from the IO concerned.
On 21st August.
Much obliged.
Not 9K.
And some courts.
Ship, in this case, we had mentioned in the morning itself, we're seeking an adjournment.
It's taken consent from the other side.
Time being.
No, he's seeking adjournment বিচাৰিছে agree কৰিছে agree he sought for adjournment in the
Yes.
morning itself. He agree apni it's agree
Okay. As agreed by learned advocates of both the parties, recess shall list the matter on
27, 28.
28.
I'm applying.
Next session.
Sergeant number 20 by VC mode.
Central Bank of India.
Okay, after some time.
At 2, my lord.
Oblige.
21.
কৰিবা তুমি
My lord.
হ'ব কৰা
My lord, in this matter, the amended cost title as per lordship's direction was filed on the 10th of August, my lord. Well, I have the documents and it's there in the High Court website as well. And my lord, on 12th, we have taken steps by speed post upon the, my lord, learned DLSA Lakhimpur by speed post with the amended cost title. On 14th, the office note is there that the amended cost title is filed. However, my lord, steps have already been taken, my lord. I also have the documents and it is reflected in the Honorable High Court CNR as well. So, my lord,
Otherwise, I have also checked the record, my lord. They have, otherwise, my lord, in this case, my lord, amended, my lord, that is petition was in the record on 14/8/26. In
Right,
fact,
right.
actually, my lord, notice was also not yet received, my lord. In this case, my lord. I have not found any order.
yes, my notice has been issued. Notice being received is not there on record as yet, my lord.
And they have
But
taken
it's general-
No,
steps. to-
you have taken a step by speed post.
Speed post, my lord.
Then obtain the this postal track consignment report.
Yes, my lord. Then the date may be fixed, but if, my lord, they appear for DLS.
No, you have not taken a step through the registry.
My lord.
You have not taken a step through the registry of this
It
court.
has been taken to the
No.
to the registry only, my lord.
Registry
But
only.
probably they have not yet uploaded it, my lord, in the office note, my lord. That is yet to be done possibly.
Okay, Kobe, do one thing. Ask them to
No, my lord, only I have
Verify it.
I have to office now only through speed post. No, they have taken steps only through speed post. That is, my lord, e-court service to me. That is,
But there it is written that as speed post, my lord. But we have submitted it to the registry, my lord.
okay,
The
all right.
document is
Taken a step. On 12/8.
12/8. We have
By
taken
speed
steps
post.
by speed
Okay.
post issue.
Ask the section to confirm it from the website. We'll take it up at 2 o'clock. He will obtain instruction from the section.
My lord.
Section will track it in the departmental website,
My
whether it was
my
served or not.
My lord. And accordingly, my lord, we'll take a call if fresh steps needs to be taken or service to be done to people.
Wait
Whatever
till
your
2
lordship
p.m.
decides.
Wait till 2 p.m.
Yes, my lord. Yes, my lord. Oblige, my lord.
22. And 22.
22 lordship nobody is appearing for the petitioner.
None appears for the petitioner on call is the matter after 1 week. In the event of
Lordship.
subsequent non-representation, appropriate orders will follow. Ms. B. Bhuyan, learned additional PP from senior advocate assisted by Ms. Wilson, present for the state respondent. After a week.
Lordship.
Madam, I am appearing on behalf of Master D. Nath, madam. He is on legging a pardon, madam. At the timing, madam. CD is received, madam.
CD receipt.
Yes.
Okay.
Item fixed at 2 p.m. Item 35 for hearing.
My lord, in this matter, my lord, I am extremely sorry to, my lord, say, my lord, earlier, my lord, Bonkim Sharma, my lord, on last of the year, but today, my lord, he is unwell, my lord. So tomorrow, my lord, or day after tomorrow, any date, my lord?
Yes.
I have not completed my part on that day, last hearing. Let me complete my part today. And my one objection is that in the last year, they have taken 6, 7 times, lordship. But till date not prepared.
On Thursday, we will hear you, not in a piecemeal manner.
Lordship,
Thursday. On the prayer being made by Mr. Portapu, Learned Counsel, appearing on behalf of Mr. B. Sharma, Learned Additional PP. And also after hearing Learned Counsel for the appellant, this matter is adjourned to be listed on Thursday.
yes, obliged, sir.
Having item 4.
Back to the lordship. So this is for transfer of a case. That is PRC 581, here from Gauhati to any other place. Now, Milord, here, basically, Milord.
So notice has not been issued
No,
here.
Milord, no. I think, Milord, the information
Transfer from which
from
place?
Gauhati to any other place, Milord. The information is.
Golpara to any other place.
Yes, Milord. The only thing, Milord, here the.
What is the ground?
Here, Milord, the informant is an advocate there, Milord. And in fact, the entire bar, that is, Milord, even Milord, when I filed a bail application there, Milord, number of objections that come in. Milord, ultimately, this honorable court was pleased to grant me bail. After two petitions were filed initially, Milord, they objected. The whole bar association was, Milord, in support of the informant. That is the problem.
So let notice go at this. We'll see. Heard Mr. D. Learned Counsel for the petitioner. Mr. Portapu, Learned Additional PP for the state respondent. This application under section 447 of the BNSS 2023 is preferred by the petitioner, namely Dr. Salim Atik Rabbani, for transfer of session case number 133 of 2025 from the Court of Learned Additional District Judge Gauhati to the Court of Learned Session Judge Nagaon. Why Nagaon?
He's a resident of Nagaon. In fact, he's serving in at Hojai. He's a
Hojai.
medical officer. He's a doctor.
Nagaon. Nagaon.
We
Or
prefer
any
not-
other competent session court in Assam. Paraphrase the petition and the documents placed on record. Let notice be issued to the respondent, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Portakur entered appearance and received notice. But extra requisite copy of the petition will be furnished to Mr. Portakur during the course of the day. List the matter. Registrar will call for the scanned copy of the record from the learned trial court. List the matter after 4 weeks. Mr. Day, your name is not there.
Yes, in fact, I had signed probably will name has not been shown. But there is, I have signed the wakalatna, but name has not been shown.
Okay. Mr. Day also submits that though he has filed his wakalatnama, his name is not reflected in the cause list. Registrar shall do the needful in this regard.
Timing item 3. Promotion.
Well, item number 3, my lord, till now charge sheet not yet submitted.
Not submitted.
Not submitted.
You are behind the bar for.
No, actually, my
it is
lord,
heavy.
4 persons were, my lord, named, my lord, 4 brothers, my lord. 2 were arrested, we were not arrested, my lord. We moved an anticipatory bail application before this honorable court that was rejected. That is at page 25, my lord. That was in the preliminary stage of
Then
investigation.
what is the case ID?
Yes.
My lord, from the page 30 order, your lordship kindly come. Against us, no material is found, my lord. It is recorded by the JMFC Hazu, my lord.
Page number 30.
Page number 30, Judicial Magistrate, first, my lord. I am reading the order, my lord. The IO has reported that investigation was conducted in routine manner recorded the statement of witnesses, etc. In course of investigation, it was revealed that the victim who was admitted to GMCH for treatment had expired on 4/9/2022, and accordingly, the postmortem was done. Subsequently, based on the said postmortem report, prayer made by the IO for adding section 302 was allowed. Thereafter, the accused persons Riazul Islam, alias Dhania, and Babul Ali is arrested and sent to police remand for 3 days. That after recording the statement of independent witnesses, no any material was found against other accused persons named in the FIR. We are the other accused persons. So, my lord, we may be allowed to appear before the IO and record our statement. Against us, no material is found.
But before that order, there is one order of this court.
Yes, my lord. This order is of 4/12/2023, and your lordship order, page 25, it starts from 26. It is 6/12/2022, my lord. After that, my lord, this fact has come. my lord.
And Babul Ali's name is in fact not there in the, my lord, your lordship may kindly peruse. The present petitioner is Riazul Islam.
Yes, my lord. 2 and 3, 2 and 4 are we, my lord.
Zakir Ali, my lord, he is accused number 2.
Zakir Ali and 3. Safid Ali, my lord, they have mentioned as Safid Ali. My lord, my name is, my lord, actual name is, my lord. Petitioner number 2, Safidur Rahman, alias Safid Ali. Safid Ali.
Who are the other persons, my lord?
They are arrested. They are arrested. They are, my lord.
Let the CD come. We'll fix a very short date.
Till then, my lord, we may be protected. My lord, we will appear because police is searching us, my lord.
No, Mr. Gogo, you see, in the order dated 18/12/2022.
My lord.
This order was passed after perusing the case diary.
Yes, my lord. Lordship come to the my lord operative portion. My lord, the last paragraph, it starts from 27. It appears that the deceased Mujibur Rahman died of injuries sustained by him over his abdomen and the same way caused by blunt force object. Also, it appears that the name of the applicants finds mentioned in the FIR. Materials collected so far in the case diary shows that their complicity with the offense alleged in the FIR. The offenses are serious in nature and investigation is going on. In view of the above, court is of the view that custodial interrogation of the applicant is necessary. In the interest of, so my lord, it was in the preliminary stage of investigation. That is in the month of, my lord, November 2022.
No, you see, that observation was made after perusing the case diary.
Yes, my report of the IO, my lord. It is. Your lordship observation was perusing the case diary, my lord.
Yes.
Subsequently, my lord, a report was called for. That is at page 29. That is a petition was filed by the informant, my lord. Page 29. Lordship come to the page 29 order. Case record put up on strength of a petition number 250 of 2023 filed by the petitioner informant of this case. Seen the petition along with the prayer. The informant lost the Azahar on 2/9/2022, which was registered by Hazu PS case number so and so, added section 302 IPC. But till today, the IO has not submitted the search sheet. It is prayed that the IO be directed to submit its status report. As such, subsequently, my lord, that 30 page 30 order has come, my lord, after status report, my lord. That status report said that against us, my lord, no material is found. After examining the witnesses, my lord. That is why I am paying for interim protection.
No, this court will go by the order of this court dated
My lord.
18/11.
Then the short date may be given, my lord. Next week, man, Hazu.
And why the report was called for by the
Because
judicial
petition
matter?
was filed by the informant.
For?
For not submitting the search sheet, my lord.
CD on Monday?
Yes.
Monday, my lord.
Updated CD.
Updated CD.
Highly available.
I mean, I have 25.
Okay. These are the copies, my lord, that we have taken steps.
Yes, Lordship, we have communicated with the
August.
IO Lordship. Notices served.
Notice served.
Yes, not served Lordship. They were tried to serve the notice, but they have failed because the whole family members went to West Bengal. Some rituals for their one of the relative died. That's why police unable to fail to serve notice Lordship. So they will be back at the end of this month, I think. As per the instruction from the I have taken from the concerned IO Lordship.
But my lord, we do not know when they will come back. And my lord, accept notice, thereafter they will appear, my lord. And make their submission with regard to.
Oh,
my
how long
person.
you are behind the bar?
My lord,
How long you are behind the bar?
my lord, he was arrested on 2nd of May, 2026. More than 100 days, my lord.
Search sheet is submitted here.
Charge sheet submitted, my lord, trial started. My lord, I have the data
Whether any
which
witness,
shows, my lord, 22/6/2026, my lord,
whether
charges
any
frame.
witness has been examined.
No, my lord, that is my whole submission, my lord. On 6/7/2026, PW is absent.
Hmm.
My lord, on 22/6/2026, summons issued, it was served. Then, my lord, directed to appear on 6/7/2026. On that day, my lord, PW is absent. Then again, my lord, fresh steps taken on fixing on 27/2026, my lord, PW absent.
No, Mr. Sen, you say
My lord,
there is a division bench order of this court
my lord.
that the notice has to be served upon the informant.
My lord, record reveals, my lord, I have gone through the records.
Hmm.
My lord, notices has been served upon the, my lord, the victim as well as, my lord, the informant. Both of them were summoned. Now, despite service of notice, my lord, that is my respectful
No,
submission.
no.
my lord,
On
four
what
occasions-
basis? On what basis you are submitting that notice has been served upon them?
My lord, yesterday the case was posted for production and evidence of the parties. My lord, I was there. I have
The
gone through
notice in connection with this bill application.
my lord, in this case, my lord, case number 73, which is trial is going on in that.
No, 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 no.
My lord.
Notice was issued in this bail application.
Correct. This to my learned friend has submitted, my lord, that notice could not be served because they left for Bengal.
Mm.
My lord, they will come back now. When they will come back? But the fact of the matter is that, my lord, in the trial court also, they remain absent for many occasions, my lord. 6, 7,
No,
20,
if
20.
they are not present in India, then how the learned trial court can examine them?
But if they do not turn out, my lord, despite receipt of summon, then, my lord,
No, as per his instruction, they will come back by the end of this month. So let us wait for some days.
as your lordship pleases, my lord, but considering
No,
the
pleasing,
period of incarceration, my lord, 100 and more days, my lord, he is behind the bars. And the fact, my lord, the materials reveals, my lord, that there is a love affair in between the teenager, my lord. The victim is, my lord, 16 years old as per the birth certificate seized by the police, my lord, investigating officer. And by the accused is 22 years old, my lord. They were in love, my lord, it is admitted. The victim has admitted in her 164 statement before the learned magistrate.
Maybe.
My lord,
she is a child as defined in section 2D of
correct,
the
correct,
POCSO
my lord.
Act.
There is no doubt about it. I
Then-
admit, my lord.
Then
I admit, my lord.
Then-
But Supreme Court in some cases, your lordship knows, my lord, that those who acquired the age from 15 to 18, my lord, they are major minor, my lord.
no,
They
no,
are
no,
major
no.
minor, and to some
No, no,
extent, my
no,
lord,
no, no.
their case, my lord,
No,
cannot be, my lord, the tested.
Here the definition in section 2D of the
Correct.
POCSO Act is very
There-
clear.
I am not disputing
There is
that,
no
my lord.
ambiguity.
I am not disputing, my lord. But fact of the matter, my lord,
that there was a love affair. my
Okay,
lord. Out of love,
let it
something has
be
happened, my lord.
in the last part of this month, Mr. Goswami shall produce the service report before this court. Heard Mr. B.K. learned counsel for the accused, Mr. Goswami, learned additional PP for the state respondent. Mr. Goswami on instruction submits that notice upon the respondent number 2 would not be served, as the respondent number 2 left for England and will be returning by the end of this month. Accordingly, it is provided that Mr. Goswami shall produce the service report before this court on last part, 28 August.
Lordship.
I'm deeply obliged, my lord.
20 for admission by vision note.
By this petition, I have, my lord, challenged the, my lord, impugned FIR charge sheet and as well as the, my lord, impugned order dated 28/4, my lord, 2026, my lord. Whereby, my lord, petition for discharge is rejected, my lord. Allegation is that, my lord, the petitioner.
Where is the impugned order, Mr. Padgiri?
My lord, discharge, my lord, rejected, my lord, order. And we see 129 page number.
129.
My contention is basically, my lord, as per pension regulation, there is a bar for departmental proceeding or judicial proceeding, my lord. The petitioner is the retired employee of the Central Bank of India, my lord, senior manager, my lord. And my lord, he retired in the year 2014, my lord. And FIR was lost in the year 2018, my lord. And event of, my lord, allegation, my lord, is in the year 2013, my lord. And kindly see, my lord, regulation, pension regulation, my lord.
Where is the regulation?
Page 72, my lord.
Page 72.
72, my lord. It is the, my lord, regulation 48. Last part, my lord, 72. Top part, provided that no departmental or judicial proceeding.
Okay, page number?
Is 72, my lord.
72.
71, my lord, 48, regulation 48. 48(1), my lord. Provided
Regulation
also
40,
that,
40?
my lord, 48, regulation 48, and page number 71, my lord.
Recovery of pecuniary loss.
Lost.
Cost of bank.
Bank, my lord.
Yes.
And relevant portion, my lord, kindly see page 72, top, my lord. Provided also that no departmental or judicial proceeding, if not initiated while the employee was in service, shall be instituted in respect of cause of action which arose or in respect of the event which took place more than 4 years before such institution. My lord, there is a bar, my lord, regarding regulation.
When the departmental, when this criminal proceeding was initiated against it?
Is set aside by this honorable court, my lord.
Pardon?
By this honorable court, my lord, departmental proceeding, my lord.
No, judicial proceeding.
Judicial proceeding, departmental, no departmental and judicial proceeding.
No, that's all right. Here in this case, when the FIR was lost?
In the year 2018, my lord.
2018.
18, my lord.
So 15/11/2018.
FIR 15?
11/2018.
2018. When did you retire?
Retired, my lord,
On 31/10/2014.
14, my lord. And event, my lord, allegation, my lord, in the year 2013, my lord.
So the
It is reflected in the FIR.
so the occurrence took place in the year 2000.
13. 10/9/2013. 10/9/2000. On that day, my lord, loan was sanctioned and disbursed to the, my lord, accused number 1 and 2, my lord.
Okay, this is the ground.
This is the main ground, my lord.
Any other ground?
My lord, any other ground, my lord, the petitioner is the only to process the loan, my lord. It is, the petitioner is not the sanctioning authority, my lord. As per instruction of the higher authority.
In the writ petition, you have challenged the departmental proceeding.
Yeah,
That was quashed.
Squash, my lord.
In that petition, you have not challenged this judicial proceeding.
My lord.
Not
No, Your
challenged.
not challenged.
Okay. Mr. Sharma, if this is the legal position, how can you initiate the judicial proceeding against him?
Your Lordship, judicial proceeding is a criminal proceeding that is on
Yes.
the ground of fraud and allegations. And
Mm.
Your Lordship, the judicial proceeding which has been written in the pension regulation at 49 and 48, that is in reference to the recovery of the pecuniary loss. And that judicial proceedings come under the head of the gratuity, and before the labor court, we will file something for recovery of the pecuniary loss, not in reference to the fraud, Your Lordship, that has been committed by the petitioner. It is completely departmental proceeding, and the criminal proceedings are separate proceedings. One cannot be affected by the other, Your Lordship. Suppose if he is been exonerated in the criminal proceeding, that is not going to affect the departmental proceeding. In the departmental proceeding, Your Lordship, he is being exonerated only on the ground of delay, that is of more than 4 years. That is why he is been exonerated. And here is one case law is also there of the Supreme Court, that is Karnataka Lokayukta Bagalkot district. Therein paragraph it is that Mr. Afriz. So there is a principle has been laid down that the departmental proceedings and the criminal proceeding both are on separate footings, Your Lordship.
No, that's all right. But here in the regulation itself, it is provided that the judicial proceeding.
Yes, Your Lordship. Judicial proceeding is in connection to the recovery.
If bar is there in the regulation itself, how can you start the judicial proceeding?
Lordship, that the departmental proceeding.
And what is the basis of your submission that judicial proceedings are only those proceedings which were initiated before the labor court?
It is in the pension regulation, Your Lordship, regarding the pecuniary losses, Your Lordship.
No, whether the judicial proceeding is defined in the regulation.
No.
Judicial proceeding not defined, Your Lordship.
Then can you interpret it only in your favor?
Yes, Your Lordship, I can place it before Your Lordship more judgments. That is, that judicial proceeding is only in regarding to the pecuniary losses that has been caused to the bank. It should be read as a whole, Your Lordship. It is in the pension regulation. It does not say that the criminal proceedings, Your Lordship. It is in civil nature proceedings, Your Lordship.
No, you come to the section 48, the main provision.
Yes, Your Lordship. Recovery of the pecuniary losses caused to the bank.
Yes.
The competent authority may withhold or withdraw a pension or a part thereof, whether permanent or for a specified period, and order recovery from the pension of the whole or part of the pecuniary losses caused to the bank, if in any departmental or judicial proceedings
the petitioner is found guilty of grave misconduct or negligence or criminal breach of trust or forgery or the act done fraudulently during the period of his service. During the period of service, your lordship. That is.
Provided.
But he is being exonerated only on the ground that is 4 years of his service.
No,
your
no,
lordship.
we are not concerned with the this departmental proceeding. We are concerned with the judicial proceeding. Here also the criminal breach of trust or forgery or
Your
act
Lordship.
done fraudulently has been mentioned.
Yes, your lordship. For the fraudulent act, we have filed an FIR, your lordship. That is, FIR filing is not barred because we have unearthed the fraud on thereafter of his service superannuated.
No, if the regulation barred in initiating any such proceeding, how can you initiate?
Your lordship, I will satisfy your lordship that these are the civil nature proceedings, your lordship. Your lordship may kindly stay the proceeding, then on the next date I will satisfy your lordship on this issue. That whether the judicial proceedings that from the forgery.
Okay. Heard Mr. Patgiri, learned counsel for the petitioner, and also heard Mr. Sharma, learned.
Number 2.
Learned standing counsel for the respondent number 224. And Mr. Goswami for the respondent number 1. Respondent number 1. After hearing learned counsel for both the parties and also considering the facts and circumstances on the record, especially Regulation 48, proviso to Regulation 48. No, third proviso to Regulation 48. This court is of the view that a prima facie case for staying the further proceeding of what is the case number?
My lord, PRC case number, my lord. 2277/2019.
PRC case number 2277 of 2019 is made out, and accordingly, further proceeding of PRC case number so and so pending before the Court of Learned Chief Judicial Magistrate Kamrup M. Gauhati stands state till next date. List the matter on
8th of September.
8th of September. For further consideration.
Oblige.
Pending 21.
May it please your lordship. But you made the inquiry, my lord. The error is at my end only because it was specifically directed by your lordship to be taken through the registry. However, my lord, at the clerical end, my lord, it was taken by speed post. So probably, my lord, in terms of the order in the IA, I'll have to take it again, my lord, through the registry.
Okay. Heard Mr. Boydya, learned counsel for the petitioner, and Mr. Borthakur, learned additional PP for the state respondent. Mr. Boydya submits that he will take fresh step upon the respondent number 2 through the registry of this court. Fair allowed, or shall list the matter on
End of this month, my lord, because the evidence date is fixed early September.
28 August.
28 August.
I stand deeply obliged, my lord, and extend my apologies.
Items for hearing. Item 34.
My pleasure, lordship, my lord. My lord, this is an appeal, second appeal. Of course, my lord, I have lost in both the courts. An appeal was admitted, my lord, on 2 substantial questions. And both the substantial question, my lord, in my understanding, my lord, relates to family settlement. Therefore, basically, court decided the relevant issues on the basis of, my lord, family settlement. And so far as the family settlement is concerned, findings of both the courts below, that cannot be acted upon, my lord, in terms of section 17(1)(b) and section 2, my lord, subsection 24 of the Indian Stamp Act. Because it must be in writing and it has to be a registered instrument. Therefore, my lord, basically, my lord, I am to make an effort to satisfy your lordship that whether there was a, my lord, admission on the part of the present plaintiff, that is present respondent, and whether on the basis of that settlement, my lord, she can have, my lord, any right to, my lord, claim the entire property despite this family settlement, whether she has got any right to claim half of that particular property, my lord, Gauhati property, suit property. And my lord, predate case of the, my lord, plaintiff is that, my lord, original, my lord, ancestor, one in Indrakanta Hazarika, my lord, died leaving behind 3 legal heirs, the present plaintiff, present appellant, respondent, and their mother. And after the death of both the parents, my lord, property devolved on her. And subsequently, my lord, she filed a suit in Shillong pertaining to Shillong property, because the ancestor died leaving behind several properties: Shivsagar, Gurhat, Shillong, and Gauhati. And so far as the, my lord, Gauhati and Shillong properties are concerned, question arose whether there is any settlement, because it is the case of both the parties in respect of both the suits, my lord, is the family settlement. My lord, she filed the suit, my lord, on the basic contention that Gauhati property is not my lord, is not covered by any family settlement. It is a undivided joint property. Therefore, as being the legal heirs, I have my half share of the Gauhati property. We filed WS. Of course, my lord, in so many words, there is no any specific contention regarding family settlement. But para 14A of the WS of the amended WS, amended WS, there is a specific contention that there was a relinquishment. And court says, both the court says, we can understand relinquishment means relinquishing is the, my lord, consequent result of family settlement. Unless and until there is some settlement, question of relinquishment does not arise. That is the findings of both the courts below. But court did not consider the plea of relinquishment vis-a-vis the family settlement. Basically for 2 reasons. I have already pointed out. One is, my lord, section 224 of Indian Stamp Act, and another is, my lord, section 17(1)(b) of the Registration Act. But as your lordship knows, and it is well settled by catenas of decision, Supreme Court as well as our High Court, that family settlement is a valid mode of disposal of the property, provided the oral family settlement is acted upon. The ancestor died in 1965. And our case is that in the meantime, there was some settlement. By virtue of their settlement, I got the property.
You were referring to section 24.
224 of the Indian Stamp Act. According to court,
224.
2(24). That is the finding of the courts. Court says, in terms of that particular provision, question does not arise to accumulate to court. Yeah, na.
224.
Key desire to evidence the desire. Equally, sir. I'm just referring the findings of the court of the court of first, and original trial court. Both of them. My lord, lordship may kindly come to page 35. That is, while, my lord, that finding
35 of your memo of appeal.
memo of appeal.
While deciding the issue number 4 and 8, court has arrived at a positive conclusion at page 35. May I read, my lord?
Yes.
It is the argument of the learned senior counsel for the plaintiff that the deposition, if family settlement have not been pleaded in the written statement, and even finally, even family settlement have not been pleaded in the written statement, even defendant admitted the same fact in his cross-examination, but it would appear from the perusal of the written statement that plea or relinquishment doesn't find mention in the written statement. This is not correct position. Para 14 of 2 of the amended written statement, there is a reference of relinquishment. The relinquishment of Gauhati properties is a consequence of family settlement. There is a finding. There is a matter of submission made before the court. Hence, even though the term family settlement has not been specifically referred to in the pleadings, the requirement of pleadings, material facts have been complied with by the plea of relinquishment, which is the outcome of such family settlement. Hence, there would be no bar in accepting the legally admissible evidence on the point of such family settlement. That was the submission made. Now, what does court say? Now, therefore, before I proceed to determine the discharge of honors by the defendant, it is necessary to lay down the requirements of law as to such settlement. Section 224 of the Indian Stamp Act defines settlement, meaning any non-testamentary disposition in writing of movable or immovable property made. Next page.
No,
For
no,
the purpose of.
if it is not there
lord.
in your written statement,
My lord.
how can you take a plea?
My lord, right, my lord, absolutely right. Absolutely right. Now, Lordship, can you look at paragraph 14 of amended written by Lord WS? Page 24. Page 20, relevant page 24. 24. Have a Lordship got, my lord? Paragraph 14A. The plaintiff has relinquished the entire claim over the Gauhati property in favor of the defendant in lieu of property, including ornaments, cash in hand, and half share of Shillong property, and Shivsagar property left by their parents, and as such, also, she cannot claim partition over the Gauhati property, and the suit is liable to be dismissed. Of course, it should have been in elaborate manner or in some explanatory manner. But facts remain, there is a reference of relinquishment. Therefore, there is absolutely no bar to adduce evidence on the basis of that particular pleadings. That it is submitted that next.
No. Here there is no mention about the family settlement.
Family settlement,
You
of
have
course
only
not.
relinquished the claim.
And relinquishment cannot stand alone. It has to be on the basis of certain understanding, offer made, offer accepted. And my lord, court says it might be the consequent result of family settlement. But we cannot accept it because it is oral. There is a finding of the court. But law says oral agreement, if acted upon for so many years, then it is admissible evidence that it may be very good, my lord, mode of transfer. It is not there, there cannot be any oral settlement. Court says maybe, but in view of section 224 of Stamp Act, as well as section 17(1)(b) of Registration Act, that will go. Therefore, my lord, in so many words, though there is no any reference of family settlement, but there is a reference of relinquishment. And that
No,
relinquishing of
no, relinquishment and family settlement are two different things. Are the same things.
same thing, unless and until there is some agreement, question doesn't arise for one to relinquish. I will relinquish my part, you will relinquish your part. Therefore, this is the agreement. Therefore, court rightly says
No,
it is a
the
consequent result.
problem
family
is that
outcome.
beyond the pleadings, a third case you cannot introduce.
No, madam, there is some pleadings relinquishment. Relinquishment, whether question will arise, my lordship has rightly pointed out, and I am obliged to answer. Relinquishment, whether relinquishment can survive without any settlement. Can I
Maybe,
just come and say I relinquish my right?
maybe.
It cannot be. It cannot be. One hand, you are claiming the entire property of Shillong on the strength of a family settlement. Now you are coming and claiming half of the share of the Gauhati property. Therefore, you cannot blow hot and cold at the same time. And assuming that there is no settlement, then what would be the status of Shillong property? That will be joint property. Therefore,
No,
whether any principle,
no, for that you have the remedy, you avail it.
avail it, lordship kindly appreciate.
Hmm.
I avail it,
Hmm.
and subsequently, when the question arose, whether it is maintainable in view of this settlement, then it has come to the notice that there was a settlement. There was a pleading made by the plaintiff. As
No,
defendant in the
you have filed this amended written statement.
my lord.
If there is any family settlement, you could have plead the same here and also enclose the deed of settlement along with this written statement. You never did it.
Regarding what, my lord? Can repeat, my lord.
Regarding the family settlement,
Right.
if there was any deed of family settlement,
Question does not, it's an oral settlement we are saying.
oral settlement,
All settlement. Acted upon.
oral settlement acted upon.
They say we cannot accept this proposition because it is
No,
an oral settlement.
Mr. Pukas, so you
Right.
say,
Right.
in express word, there is no pleading.
Right, my lord.
And there is also no written this family settlement. It is only oral settlement.
The oral
And
settlement, whether it can be acted upon. Because
No,
they took the advantage of this oral settlement so far as the Shillong property is concerned. Same question might have arisen, my lord. On what basis you are claiming entire property? And you say Shillong property is a joint property. I am equally entitled to half share. You made specific statement in your WS that is a family settlement. Advocate also submitted before the court there is a family settlement. Therefore, in view of this,
no.
yes, my lord. Exhibit 11. Exhibit 11, order of the court, Shillong court was exhibited as Exhibit 11.
Where is that agreement?
Exhibit to the
Oh, where is that exhibit?
Yes, my lord.
In the trial court record or in this?
No, trial court record.
We have given the type copy.
Type copy.
No, I quoted to idea. Well, record is before your lordship, my lord. Exhibit 11.
C1.
No, Sancho Prasad.
Oh, to see. Get what? See to. Mr. Borwa, where is the copy?
Last occasion I had provided that your lordship has instructed me to give a legible type copy. Accordingly, in last occasion when I appeared, I had
furnished it.
given. And my lord, I think it is in with us, but that copy was provided, I think.
Which is the relevant portion here?
Page 3.
Page 3.
Page 3. May I read, my lord? The suit property in question was transferred to OP defendant number 1 as far as back in 1974 by transferring the name from their father, late Indrakant Nath Hazarika, to the name of the defendant on the basis of a family settlement after the death of their father. Therefore, there is a clear reference, and that was taken note of by the court. And court discarded that part of the, my lord, part of the submission or pleadings, saying that by referring section 18 of the Evidence Act, court said it is a mere statement of the advocate. Therefore, we cannot accept it. How can court say so? Because there is a pleading, they filed WS, and in that WS there is a clear reference of family settlement. That apart, my lord, if it is an admission on their part, then section 58 will come into play. That part was totally ignored. Of course, my lord, there is a lapse on our part to be frank enough, my lord, to be, my lord, fair enough. That was not the
No,
submission.
this is also a submission of the council.
Yes. But based on what? Based on pleadings?
No, this is not the finding of the court.
Not necessary. Section 58 is absolutely clear. If there is an admission, either by the party concerned or the advocate in course of hearing, then it need not be proved. The question is whether the admission or not. And if it is an admission, admission need not be proved. Section 58. Unless court in its discretion says that this admission is required to be proved. And where is the findings of the court? That court has exercised judicial discretion. And court wants the party to prove it. Straightway court has come to the conclusion. Because language is absolutely clear. If I'm not wrong to understand, section 58, facts admitted.
No, that's all right. But whether this order was exhibited before the trial court?
Yes, yes.
Yes, exhibit?
Exhibit 11.
11.
Yes. Court accepted the factual position that there was an oral settlement, but discarded. Court accepted there was a submission made by the advocate in Shillong case, discarded, saying that this is a mere submission of the advocate, not the findings of the court. Question doesn't arise. If I say that there is an admission on your part, and section 18 of the Evidence Act, advocate on being authorized, if makes a statement, court will presume that this is a statement made on behalf of the party concerned. How can he escape? Or how one can escape from that statement? Otherwise, there is no meaning to submit Bhukalatna and appear on behalf of the client and make submission before the court. I know, my lord, it is a very, very hard case for me. I lost both the case. And for that, my lord, I will make a prayer before the court or request before your lordship that entire judgment be, my lord. At least I may be allowed to read the entire judgment. Court is dubious. Court says, once there is an admission on your part, subsequently you turn back saying that no, my lord, there is no settlement. Then burden will go to you to prove the non-existence of the fact. Normally, my lord, negative aspect cannot be proved by positive evidence. Therefore, law is well settled that non-existence of fact need not be proved, cannot be proved. But once you have made that there is an admission on your part accepting settlement, subsequently you turn back saying that there is no settlement. In that case, you will be obligated to discharge your burden and prove the non-existence of fact. That is the findings of the court. And court suddenly twisted and turned back and diluted the entire, my lord, factual situation by saying that it is an assertion, it is a mere statement of the advocate, not the findings of the court. Suppose, my lord, supposing, Lordship will not take it otherwise, supposing I am an advocate, I made a statement before the court. I have the instruction not to press this petition. And what would be the next rule for the court to play? Obviously, my lord, petition is dismissed on a trial. Can, my lord, subsequently the petitioner, my lord, approach the court and say that, no, I have never instructed the advocate.
No, that is going on. There are several cases.
That is a different question. He is to prove that beyond authority he acted. Beyond authority he has made this statement. Yes,
Thereafter, the party entered appearance before this court and filed that I have not instructed the council to withdraw the petition.
Now, where is the, my lord, where is the efforts made, where is the endeavor made by the petitioner, by the respondent? That this is not my statement. Whether you accepted the entire property. Advocate on his stand, on the basis of Wakalatnama, have the authority to represent the client and to make submission. Whatever is, my lord, good for him, whatever is betterment for
yes,
him.
Mr. Counsel.
My lord.
This as per section 18 of the Evidence Act, admission made by a party to a proceeding or his agent is also admission.
But let me come to the controversy. What is the controversy today? Today, what his case is that there was a family settlement. And as per this family settlement, the property in Gauhati, that is the suit property before my lords, went to me, and the property in Shillong went to you. This was a family settlement according to him. We are siblings. He is my brother. Now, assuming this was a family settlement, it was not pleaded in the written statement. There is no pleading in the written statement that there was a family settlement. Subsequently,
that is not there. But
yes,
regarding the
very well.
relinquishment,
Assuming, he says relinquishment in an amended WS. Assuming there was a family settlement, I am assuming a situation that there was a oral family settlement. And as per Kale and those series of judgment, oral settlement family settlement is accepted if conduct shows that we have acted as per the family settlement. Now, assuming there was a family settlement, and assuming Gauhati went to him and Shillong came to me, then why did you go and file this suit in Shillong, challenging my ownership of the Shillong property, which according to you was as per the family settlement?
Because you accepted the position.
This exhibit 11, what is exhibit 11? His family, I'll make it very clear, Bella. I'll reply after my letter senior finishes. But on a very short point, he says there is a family settlement. As per family settlement, Shillong went to me, Gauhati went to him. No dispute. I accept his case for a moment. There is a family settlement. Now, as per this family settlement, I went ahead and I sold Shillong property. He is in Gauhati. Now, after I sold Shillong property, what was the occasion that in 1991, you came and filed a suit in Shillong questioning my right over the Shillong property? If as per family settlement, I was the owner of Shillong property, why was this suit filed? Exhibit 11, now sir, just a minute. Exhibit 11 is a suit filed by him in the court in Shillong, a title suit saying that I had no right title interest to sell off the Shillong property. He cannot on one hand say that there was a family settlement and we acted as per family settlement, and therefore today this claim over Gauhati property is contrary to family settlement. That cannot be his case. If there was a family settlement, there was no occasion for you to file a suit in 1991 against me in Shillong. And that is what both the courts have held. The trial court, the trial court says in the impugned judgment that your own case of family settlement is self-contradictory. Because on one hand, you said there is family settlement. And on the other hand, you yourself go and file a suit challenging his claim over a property, which as per you went to him under the family settlement.
I have the answer.
That finding is reiterated by the first appellate court, saying that yes, you are saying family settlement, apart from the fact that there is no pleading of family settlement. Secondly, if the family settlement is oral, the burden of proof and the burden of pleading is even higher. When we plead an oral contract, you will have to say when, how, who was the witness, when did it happen. None of that is there. But in any event, both the trial court and the first appellate court said that your case of family settlement is self-contradictory. And it is self-contradictory because if as per you, I was the Shillong owner, then why did you file a suit against me in Shillong? So today, can you blow hot and cold? Today, can you say that I filed a suit in Shillong because there was no family settlement or because there was a family settlement? And today, I am defending this suit again on the basis of family settlement.
I have the answer. I have the answer.
This is taking two completely different stands without any foundation of family settlement. Section 18, I understand what is the connote of Section 18, a statement made by a counsel holding authorized by the client with a statement made by the client. I also understand under 58, a matter which is admitted, matter of fact which is admitted does not require to be proved. But the whole case on family settlement, my lord, first of all, there is no foundation. Secondly, the case on family settlement itself is self-contradictory. Because if he accepts the family settlement, then why did he file the suit? Let him first answer that.
Yes, I will answer. My lord, so far as his submission is concerned, there is some deviation from facts. Who has filed the suit first? And what was the compulsion for me to file the suit? You filed the suit first. If that proposition of fact is applicable to me, same is the consequence. In spite of having Shillong property, entire property on the strength of family settlement, and what has prompted you to file the suit at Gauhati? And that suit was filed by her. Subsequently, we filed the suit.
No.
Yes.
His suit is 91, my
No.
suit is 96.
No.
That is factually incorrect.
No.
My lord,
Renumber. That was renumbered. 96 is renumbered.
my suit was on a simple point saying that this property in Gauhati is a property which was left behind by my parents and we have half share each. This was my case. And that is why I filed the suit. That suit came to be decreed and we are in a second appeal now.
So why did
as
you
far
file
as
the
the
suit?
Shillong is concerned, if it was his case all through, that was my property, then his own conduct shows that there was no family settlement. That is all that I am trying to say. Who filed the prior suit, who filed the subsequent suit is not the matter relevant here. Here, when you are pleading a oral family settlement, your oral family settlement can be proved only by conduct of parties. That is what Kale says. You will have to see whether the parties, whether there was an agreement or whether the parties have acted in furtherance of an oral settlement. Here, they themselves have not acted in furtherance of an oral settlement. Whether my suit is prior or his suit is prior is irrelevant. The fact that you made a claim contrary to a family settlement pleaded by you itself takes away your case of a family settlement. You cannot say that there is a family settlement and then plead a case contrary.
Okay, please sit down now. Let him answer.
Yes.
My lord, kindly see how one can say the suit was filed in 1996. Suit was filed in 1990. 90. That was renumbered, my lord, as 96. Where is the question, my lord? We filed the suit first. Therefore, my lord, if that particular, my lord, factual situation goes against me, in spite of having, my lord, a family settlement, Shillong property will go to him, Gauhati property will come to me. Despite that, my lord, I made a suit. I filed a suit claiming half of the property. The same facts is applicable to you. You will be stopped, you will be barred, you will be precluded. You file the suit. Therefore, we say that, my lord, under compulsion, we have to file the suit. If you cannot sacrifice, my lord, your right, despite the family settlement, and my lord, claim half of the Gauhati property, why should I not? And he is talking about the conduct. Look at the factual situation and entire background. Father died in 1965. In between there was settlement, I say. Then 67, I obtained the mutation. Then 1971, my lord, I obtained loan. They did not bother, my lord, to raising objection. They rather gave their consent. Then 74, he got the mutation. I did not raise any objection. Then they filed the suit after the death of my parents. Even, my lord, should kindly appreciate one thing. So far the conduct is concerned, if you have the half share of the Gauhati property, then what has prompted you to take a portion of the, my lord, residential building on rent? You are the owner. How can you, my lord, and what is the special reason, despite your 50% share, entitlement, ownership, you took the half of the, my lord, a portion of the, my lord, residential building on rent? Is it not a conduct in my favor? Is it not a conduct that you, my lord, relinquish your right? Subsequently, you filed the suit, and I had to file the suit on the same proposition of facts. Settlement basis, you got the property. So why should I not get the, my lord, Gauhati property on settlement basis? That apart, my lord, there is a total non-disclosure of facts in the suit. They did not bother even to make a reference. The Shillong property I got on the basis of a family settlement. Other two properties were divided between the parties, both the parties. What is the reason not to disclose that fact? Had there been a disclosure of the facts, then he would have been required to explain the basis of getting the Shillong property and tell. And that is the reason not to disclose the facts. Therefore, these are the conduct on the part of the plaintiff, which shows that she was aware of the family settlement. And it was because of that reason, since 1967, she did not make any claim. It was only after the death of their mother, she filed this suit.
No, Mr. Purkes,
Right.
now you see, though there is a contention that there was a family settlement.
My lord. In
And
evidence,
there is a family settlement, but the conduct of the party shows that there is no settlement. There was no settlement.
No, if there is no settlement, on what basis you got the property? Shillong property? The whole of the Shillong property? Let him explain, let her explain. What is the basis? You cannot, may not take the property on the strength of family settlement, and you cannot at the same time prevent me to get the property on the strength of that family settlement. Then what will be the ultimate result? If there is no family settlement, then there must not be any family settlement even in respect to Shillong property. Then Shillong property will be a joint state property. Joint state, undivided family property. Therefore, you cannot say there is no family settlement because you got the property on the basis of a family settlement. And what is the finding? She kindly let me, my lord, go through the entire judgment, because entire trial court judgment dealt with all the questions contrary to law.
No,
Issue
no,
number
no,
1
not
and 4 and 8.
necessary to, Mr. Purkes, so it is not necessary to read out the entire judgment.
Because, my lord, we have challenged that there is a purpose finding.
No, maybe. We will go by the substantial question of law framed by this court
But
only.
for substantial question of law, my lord, if we want to answer the substantial question of law, then I will have to refer that the finding pertaining to particular facts, particular issue.
Maybe you may refer, but reading of the entire judgment is not necessary.
Otherwise, my lord, I cannot answer the substantial question of law. Substantial question of law, my lord, related is connected with all the issues. The sum and substance of all the issues. And my lord was pleased to, my lord, frame these two substantial questions, keeping in mind that all the issues are, my lord, very, very relevant. It is a case of perversity, both on law and facts. Therefore, it is open to me to, my lord, re-examine the entire factual situation plus, my lord, findings of the court.
No. On perversity, no substantial question of law was framed.
There are only two substantial questions of law, and there's a subsequent, there are three. Subsequently on commissioner on
Yes,
partition.
my lord. Lord,
Order
can we see
26 rule 10.
issue number, my lord, substantial question number 2. There is a, my lord,
When, by which order?
Well, 1/6.
1/6 order, which was, my lord, when the appeal was admitted on 2 substantial question of law. One second
No,
substantial question of law.
2014, the substantial question of law.
No, thereafter at 1/6/2022,
Court has framed one more.
one additional question of law.
Okay.
That is order
lord.
26 rule 13.
Yes.
Which, my lord, I'll satisfy my
My
lord
lord.
at the relevant.
Therefore, my lord, it is not that we didn't raise the question of perversity. My lord, substantial question number 2, whether the findings of the learned court below that the Shillong property is the absolute property of the plaintiff respondent is perverse. We have said, my lord. Therefore,
Which one?
unless,
Which one?
my lord, issue number 2, substantial question of law. Second substantial question of law. Whether the findings of the learned court below,
Okay.
therefore, unless and until I be allowed to go into the judgment and apprise your lordship, I cannot answer satisfactorily. It is up to your lordship, it is my appeal, my request. Had it been not a ground of perversity, my lord, had it not been challenged on the ground of perversity, question would have been otherwise. Court is very, very reluctant to, my lord, re-examine the concurrent findings.
So what are the issues framed by the trial court?
Yes, madam. There are as many as 9 issues.
Page 28.
28. May I read, madam?
Yeah.
Whether suit is maintainable in present form, whether there is any cause of action for the suit, whether the suit is barred by limitations, whether the plaintiff has right title interest and possession over the suit land as described in Schedule A, whether the plaintiff is entitled to half share of the suit property, to what relief or reliefs the party are entitled, and whether the defendant has acquired title over the entire suit property by right of adverse possession. Basically, madam, 4 and 8, these are the 2 most relevant issues, my lord, and both the issues are decided jointly. And issue number 8 relates to family settlement. Whether the plaintiff has relinquished her claim over the Gauhati properties in lieu of half share of Shillong property and Shivsagar properties and other movable properties as per family partition. This is the additional issue framed. It was a keen contested suit, my lord. Senior advocates, all senior advocates appeared. And in comparison to them, my lord, have no existence. Therefore, my lord, apprise, my lord, request your lordship, perhaps the findings of the court needs to be re-examined when there is a question of perversity. If your lordship, my lord, permits me, then I can bring on record by giving a short note, just, my lord, pointing out the relevant portion of the findings of the court. That will be more helpful for the court.
Okay, then you come prepared with one short note. Yes.
Well, I will only see page 38. Well, today the scope under section 100, well, we cannot
very limited,
get the
that's all right.
evidence and the facts. For a
No,
moment, page
no.
38, this is the
No,
trial
no,
court's
no.
finding, madam.
You see, there is one substantial question of law on the point of perversity.
On perversity.
So if that is there, then we have to examine the matter.
For a moment, page 38, just one paragraph, my lord, which page 38, this is what the trial court says, my lord. Assuming everything my learned senior is saying is correct, I am going to the second para at page 38. Assuming for a moment that it were possible to prove family settlement by conduct, whether the sale of Shillong properties by the plaintiff raise an inference of her relinquishment of Gauhati properties is a matter to be discussed. In this regard, the deposition of the defendant, that is him, defendant in para 19 of the affidavit would show that the defendant himself disowned the family settlement. The defendant deposes that he filed a suit in Shillong against the plaintiff demanding half share of the Shillong property, as the plaintiff filed the instant suit in violation of the family settlement. The defendant deposes that he filed the suit out of compulsion, but the defendant pursued the said suit for a considerably long period, hence the compulsion should have been elaborated. Interestingly, the plea of relinquishment set up by way of amendment runs contrary to what has been pleaded in paragraph 7 of the written statement, where a defendant states that the plaintiff consented to mutation for Gauhati properties but requested defendants to allow her to sell the property for her father at Shillong. But the defendant did not agree to such proposal of giving up his claim in respect of Shillong property. This plea in paragraph 7 of the written statement shows that the defendant still claims Shillong property, and that is why he reserves his right to claim possession of Shillong properties. The defendant further states that he demanded possession of the Shillong properties, but the plaintiff, in order to counterblast, has filed an instant suit. So his own case is contrary to the family settlement. And then finally, just one more thing, my lord. Exhibit 11 is what my learned senior is harping on. No, just one, sir, you file your notes.
I am not.
Now, my lord, will just see the last page of this exhibit 11, this type copy, just the last page. If it was his case that there was a family settlement, he wanted to establish, he wanted to prove that my suit was a counterblast, please see what happens to this suit. Hence, last part, my lord, last part. Hence, on the ground of default of the plaintiff for non-prosecution, the suit is dismissed. He does not prosecute his suit. He takes up a case that there is a family settlement. He acts contrary to family settlement, files the suit. Then he does not even prosecute the suit. Today, in my suit, after having obtained the decree, after that decree having been confirmed by the first appellate court, in a second appeal, my learned senior is saying, my lords, on the ground of perversity, that he'll set up a case of family settlement. My lords, without the pleading, his own suit dismissed for non-prosecution. In my suit, no pleading. The word family settlement is not there in the written statement. Only a word relinquishment has been added by way of an amendment.
No.
And in a second appeal under section 100, my learned senior, with all due respect, is now saying on the substantial question of law that there is a perversity and trying to say that the facts have to be gone into to establish a family settlement. Is it permissible?
My lord, he is talking about disowning of my right by filing a
It is
suit.
impermissible, man.
Yes,
That's my respectful submission. I leave it to my lord.
Lordship, he argued that I disowned. As your lordship knows, law is well settled. Doctrine of, my lord, waiver, estoppel, acquiescence, these are all equitable principles. There cannot be any estoppel, there cannot be any waiver, there cannot be any relinquishment, so far as my statutory, fundamental, and other rights are concerned. Olgatilis case, 1980 Supreme Court, page 180. There cannot be any estoppel, there cannot be any disowning against my right.
I am not disputing a single
Therefore, he
proposition.
is saying, my lord, disowning. Thereby, my lord, merely
Mr.
by disowning,
Mr.
the status of the
Purkayastha,
property will not be changed.
Mr. Purkayastha, you cannot approve it or reprove it at the same time.
He also, my lord, she also. She also.
Well, I am
She got the property
accepting
on the
every legal
settlement.
proposition that my learned senior is making. I am
My
accepting.
lord, let him explain. I will withdraw my case. Authority. Let him explain that what is the basis of getting Shillong property.
My lord, may I only request for a
Now
short
he is
date?
saying there is no, she is saying there is no.
May I only request for a short date? Well,
Yes,
it's on a
but-
very narrow issue, my lord.
Yes, all right. But opportunity has to be afforded to him also.
No, I completely understand, my lord. Let him put in a note.
I will be grateful, my lord.
Even I'll put in a short note, my lord.
Yes, sir.
And I'll
Yes,
give him
sir.
an advance copy.
Yes, sir.
Heard Mr. Purkayastha, learned counsel for the appellant, and also heard Mr.
K. Talukdar.
K. Talukdar, learned counsel for the respondent. Heard in part, list the matter on.
Lordship, kindly fix the matter. If otherwise it's convenient for the court as well as my friend. My lord, any date after 16th
Of
September.
Too long a date, but 2000.
You got the relief in both the courts. What is your anxiety?
2014 matter there in possession of the property.
You will get the half of your share. Don't
No,
worry.
second week of September.
Second week of September.
Yes.
My lord, commencing from 14. Otherwise, my lord, first up, my lord, first part of the September, number of cases are fixed, my lord.
Maybe 8th of September. This is old case.
8, my lord, 8, my lord. I'm extremely sorry, my lord. 8, my lord, I have fixed today, court number 1 fixed a matter on 8th. 9 also fixed by Kaushik, Justice Kaushik today.
September.
Then Lakshmi kindly fix the matter on 15th. I will
Yes.
not take any further time.
Talukdar.
Talukdar, kindly
I don't
consider.
say what it is.
তুমি দুটা করে লিখিছা কি প্রবলেম তোমার 15th of September.
Okay.
I'm obliged.
So 15 doesn't part third item.
Yes, yes,
Possible,
yes.
my lord, that is the first item. If it is.
Part.
Part man.
I'm written.
Timing item 5, promotion.
The Lordship has directed us to place the case there. In fact, in connection with a bail application of that particular case diary was there. Lordship, kindly, I'll just indicate for Lordship.
So is there any material against the present petitioner?
There is none. Lordship, kindly peruse the horizontal flags. I have put some flags horizontally.
Page number?
Horizontally, I have kept some flags. Lordship, kindly see that.
Yes.
The main accused, Biddut Burhagohai, he was arrested. And his statement kindly see, next page. The first flag is the diary, the relevant portion of the diary. Second page, kindly see, that is his statement.
Statement of Biddut Burhagohai.
Biddut Burhagohai. Then Lordship may kindly take up the other horizontal flags. Three flags I have, pink color flags are there. Kindly take that one. From the statement of Vidyut Burhan.
The question is whether these evidence are sufficient to.
The Vidyut Burhan statement indicates two things. One is he has a direct link with an alpha cadre, and he used to transfer money into the account of that alpha cadre. And during investigation, it has also come to the authorities that there are several monetary transactions between Vidyut Burhan and this petitioner. He used to transfer the money to an account in Mon, in Nagaland.
No, who used to transfer the money?
Vidyut Burhan.
Vidyut.
Yes, my lord.
And it was from his account.
It is from Vidyut Burhan's account.
Not from the present petitioner's account.
My lord, there are a lot of transactions between the present petitioner and the Vidyut Burhan.
Where is that document?
But in fact, the later statements, if Lordship kindly takes up, it indicates that the cartridges which were received, which were recovered from the house of Vidyut Burhan, he has stated that those he has collected from the petitioner. That is number one. And other Lordship will during the course of investigation, they came to know that a lot of transactions are there, between Vidyut and the petitioner, monetary transactions. And since the Vidyut Burhan is directly transferring money to an account of Alpha Cadre, there is doubt as regard the, so therefore the notice was issued to the petitioner for investigation. Ultimately, the notice is there. He was issued a notice. He did not respond to that.
Okay, we'll see the case area and we'll pass the order on interim pair.
Lordship.
Next item.
Lordship, only thing that I want to say is that here I want to submit that your lordship, this particular interim prayer, since your lordship was pleased to raise the issue of that Niharika case on the earlier occasion, your lordship. So with the interim prayer is molded, only my protection may be given and direction may be given to cooperate with the investigation. And till the disposal of this case, your lordship, I may not, custodial arrest may not be done, your lordship. That much only I interim, your lordship.
We'll say subject to availability of material against you in the case diary.
Lordship, till
This
We'll
is the
see.
case, this is the case where materials are there, lordship will find that direct link how the money has been extracted from people in the name of Alpha by Alpha and their associates, lordship will find in the record. And this is not the case where the petitioner should get the privilege, this has to be investigated thoroughly. Lordship may kindly record our submission.
But that's all right, but merely because some transactions are there. And in absence of that, those monies were collected from the from some of the persons. And you see, there is no FIR from those victims.
no FIR.
But that is what lordship may consider. FIR was filed in the month of March 26. On 4/7, that statement of Bidyut Burhagoi was arrested on 4/7 in the month of July. Then only these things came up. And accordingly, the matter proceeded and the notice was issued to the petitioner on 4/7/26.
No, that's all right, but there is no statement perhaps by any of the victim implicating the present petitioner that they have paid money to him.
In fact, I am one of the potential victim of that area. I am a reputed businessman, and the persons named in the FIR as victims, they are my friends. I am a potential victim. I also want to help in the investigation, your lordship. Next time, this kind of extortion demands may come to me. I have annexed all the documents regarding my credentials, your lordship. I am a government contractor, class 1A contractor, your lordship. Reputed person of the locality, your lordship.
But if he is a
One of the victim is a friend of mine.
If he is a victim, if the petitioner is a victim,
No, I am not a victim.
and
I can be a potential victim. That is
he
what I am
has
submitting.
given money to Bidyut Burhagoi in connection with that. Ultimately, a notice was given to him. Let him come and depose before the police. He has asked, he is not. Police is not. Is not in a position to trace him out.
In fact, I sincerely want to cooperate with the investigation.
We can do one thing. Let him appear before the IO.
Yes, your lordship.
Until then, there will be interim protection.
That much.
We'll see the statement.
This is lordship may consider the case that is with your lordship. Lordship may consider whether this is a case.
If you can collect any material against him, we will discharge the interim order.
Yes, your lordship. The interim order may be conditional, your lordship.
Kindly, lordship may consider. Lordship, this is not a case where when the petitioner comes before the honorable court, they come out with many pleas. Ultimately, lordship may consider. On the case that is there, whether Bidyut Burhagoi statements and the materials which are available in there, lordship will consider.
No, Mr. Nath, you see, your entire case is now depends upon the statement of the petitioner.
Bidyut Burhagoi.
No, this petitioner.
Lordship.
Now you want to record his statement.
Yes, your
lordship. Police wants to see from him the bank details and all these things. Where from he has got the gun and all these things, because the cartridges were recovered. Bidyut has said that this belongs to him. Lot of things are there. So that has to be investigated.
I also want to cooperate with the investigation, your
No,
lordship.
that cooperation to what extent lordship knows, because he is now before the honorable court.
So this matter may be
No, you record
These are serious issues involving.
No, Mr. Nath, you record his statement. If he fails to cooperate with you, then we will see.
Lordship.
We will cancel the interim order.
Yes, your lordship. That much only.
But this will encourage. This will encourage many people. Lordship may kindly consider and lordship will pass order.
How it will encourage?
But he is not the only person. Bidyut Burhagoi is not the only person. Ultimately, lot of persons are there.
No, it is not your case that he has instigated the other persons.
So only after investigation it will come up.
No, therefore,
he's not.
You record his statement. We will see.
He's not traceable. Ultimately, police should not be. Lordship will not.
Okay, we'll see. Yes, next item. Obliged.
Obliged, okay.
26.
Lordship. Lordship, on last occasion, I was asked to submit a list of witnesses on which I am relying upon. And I would like to submit a short submission, insufficient. May I,
Okay, furnish a copy to him also.
yes, yes. What is the copy? Yes, copy. Copy is there. This one. This is my short written submission regarding the entire evidence which is there on record. Now, there is a Assam Police Act which was invoked at the time of filing the CS. The investigation was done in that line also. And there is a violation of 98K of the Assam Police Act for for violation of section 47 F and Z, apart from 120B and 7B of the PC Act. So if we see the Assam Police Act, then also there are certain omissions and commissions, and a grave suspicion was raised at the time of framing the charge by the trial court. And accordingly, the continuity of prosecution was allowed.
You got a copy?
No, my lord. No, I'll which one? This one. Got it.
Let us do one thing.
My lord.
We adjourn the matter
My lord.
for a short date.
My lord.
You go through the same.
My lord.
Heard Mr. Das, learned counsel for the petitioner. Mr. Hassan, learned special duty for the state respondent. Heard in part, list the matter on 10th of September.
My lord.
Deeply obliged.
This matter related to passing of a complaint matter.
You received the papers?
Lordship, I am newly appointed as the amicus curiae. Kindly allow me 2 more weeks to go through the brief of the case.
You have not been furnished the copy of this petition and the 11 papers.
I have received, Your Honor, but I need some more time before Lordship can.
She wants more time to go through the papers.
Second week of September then.
Heard.
Heard Mr. Kotoki, learned senior counsel assisted by Ms. Lenso, learned counsel for the petitioner, and also heard Ms. Sahina Nazneen, learned amicus. Huh? Are you not Sahina Nazneen? Yes. Okay. You are junior to Nazneen?
Yes, Your Honor.
Okay.
She's on leg at court number 10.
Okay. Okay. And also heard Miss, your name?
A. Yasmin.
Learned counsel appearing on behalf of Ms. Sahina Nazneen, learned amicus for the respondent. the learned counsel appearing on behalf of the amicus submits that he may be granted some time to go through the record. Pair allowed recess the matter on
17 September.
17 September.
That's then can it 17, but does it be Sokoma Puja? Let it be.
Court is open.
Court is some personal problems.
22nd September.
22nd.
22nd. Item 38.
Mr. Ali, you are for the petitioner.
I am for the petitioner, my lord. 125 proceeding, my lord. And lord, if your lordship go by the judgment, my lord, asset and liabilities was not filed. On the basis of statement of the wife, my lord, maintenance was awarded. Page 18, paragraph 18, my lord.
On the basis of statement of the
Wife.
wife. No, you say when the this judgment of Rajneesh versus Neha was
Yes,
pronounced, when?
This is my subsequent, my lord. That was in 2021.
2021.
And on this
No,
point, you lordship.
no, the question is how prejudice is caused to you.
Now, the Honorable Supreme Court has, let's set the guideline, man, and on this point, my lord, your lordship remarked the matter.
No, that's all right. We have decided some
But
cases on the
lordship.
basis of that, all right. But how prejudice is caused to you?
My lord, he has no income, my lord, as per statement also, my lord. And
he means this a petitioner.
Yes, my lord, the petitioner, my lord.
He has no income.
No, he was, my lord, initially appointed as data operator and he received some contextual amount, my lord. On the basis of complaint filed by the wife, he was terminated from the service.
No, even then,
and
you are an able-bodied person. Then you are
that
supposed to make payment of the.
And subsequently, my lord, she has got remarried. So, my lord, the husband
Remarried?
can. Yes, my lord, and they have admitted also. So, husband
No,
can find
till the date of remarriage, you have to maintain her.
So,
when she is got remarried?
2024, my lord.
24.
2024, my lord. But if I just state some facts, my lord, the judgment was passed on 4/1/2022. In the judgment, my lord, it was stated that 5,000 per month is to be paid to the first party and 3,000 to the minor daughter. Thereafter, my lord,
Total 8,000.
total 8,000.
8,000.
Thereafter, my lord, they filed an IA, my lord, saying that that has to be modified. And my lord will kindly have a look at the, my lord, order on 25/11/2002, 22 of this Honorable High Court, my lord, wherein it was said that out of 5,000, the petitioner will have to pay 4,000 to the first party. And the 3,000 to the child was kept intact. It was not touched. So earlier it was 8,000. Now
Subsequently,
it's
it was
7,000.
7,000.
7,000.
Yes.
Yes. So that, my lord, had to be paid from the date of filing. But to my knowledge, my lord, during the first phase, that is till, my lord, this order was passed, no payment was made. Till, my lord, 25/11/2022, no payment was made. And after that order was passed, she had been paying, my lord, around 1,000, sometimes 1,500 to the first party till the date of her remarriage, my lord,
No,
2024.
how much amount you have received?
My lord, that has to be calculated, and 1,500 has been paid to the child till March 2026. And regarding the remarriage part, my lord, during the subsistence of our marriage, my lord, he had already married, my lord, to one Meenakshi Das. That is in the evidence also, my lord. Our marriage, and my lord will also see, there was a categorical order on 27/22/2000. There was a categorical order on 27/22/2025, wherein this honorable court directed them to clear all the area within 1 month on 27/2/2025.
Pay the amount.
lordship, I will take instruction, my lord. Regarding, we have to also calculate by the court, my lord.
This court.
No, my lord, by family court, because he has already submitted, deposited some amount also.
No, that's all right.
Lordship,
Find out the actual amount
lordship.
which you are due to pay to her. And only then we will hear this matter. And in respect of the child, you have to continue to make payment.
Regarding child, my lord, has petition. Regarding child, my lord, the petitioner, my lord, he has to pay. There is
Yes.
no dispute.
Yes.
Lordship. Yeah.
And regarding the
Regarding wife, my lord, the
till date of remarriage.
and that was also, my lord, we took plea there, my lord, the adultery also there. It was not considered then, my lord. SS and liability was not filed. And so we will pay some reduction also, my lord.
That can be decided.
Okay, we'll consider your fair. First, you complete the area, clear the area.
Yes. But if area is paid to the wife, my lord. Now regarding the daughter, my lord. Wife amount is dispute. We are also, my lord.
But at least they are ordered
Regarding wife, my lord.
1122 may be complied with, my lord. 25, 11,
Then it will be interest was, my lord. If the husband paid entire amount, my lord, to the wife.
till remarriage, my lord. Till the date of remarriage.
After marriage, she will not get.
Till the date of remarriage, my lord.
After marriage, my lord, she will not get.
At least that may be complied with.
So
Yes,
some
sir.
consideration.
But you do one thing. You deposit the amount before the family court or family court.
Family court.
Family court, Gauhati. Okay, you deposit the amount there.
Family court both later.
Release part we will consider later on.
Yeah.
You first deposit the amount. Heard Mr. Ali, learned counsel for the petitioner, and Mr. S. Das for the respondent. After hearing learned counsel for both the parties, it is provided that the petitioner shall deposit the entire backlog amount before the learned trial court,
Family court.
family court, within a period of one month from
1
today.
month he cannot, my lord, because due to non-payment, my lord, he has already suffered 1 month imprisonment. He has, he has already suffered 1 month imprisonment. জেল গেছিল তো হ্যাঁ অর্ডার আছে হ্যাঁ warrant subsequently also warrant has been issued.
He has not been sent to jail.
Subsequently warrant has been again issued.
Okay, before the principal, there's a family court within 2 installment. Within 2 installment. No, not within, in 2 installment within a period of 2 months from today. Mr. Ali.
By order dated 19/3/2026.
No, within 2 months from today in 2 installment. However, the learned principal shall not release the amount till without leave of this court. List the matter on COVID before vacation October.
On 8 October.
8 October. 8 October. And you calculate the amount which you were entitled to. And you also calculate the amount. August 18. 16 October.
Last day before vacation.
No, it will hearing matter to know the amount of payment.
August.
Oh, 16th of October.
Well, highly obliged.
Item numbers 39 to 41.
May it please your lordship. But with the three connected matters, your lordship. Item 39 is and all three arises from the same assessment order of the respondent department, your lordship. So item 39 is the company Flamingo Breweries, and the two others are the directors, your lordship. So lordship, I'll refer to item 39, your lordship, that will cover both the other two cases, your lordship.
Yes.
Yes. Lordship, will kindly turn to page 18, your lordship. The complaint case was registered. Annexure A. Lordship have it. Yes. This case was registered against Flamingo Breweries Private Limited. And your lordship, at page 19.
Yes.
Yes. They were seeking of your, the offense is tribal under section so and so of the IPC and under section 276D/277 of the Income Tax Act. Lordship will kindly come to para 2. The assessors filed its return of income for the assessment year 2016 and 17 on 17/10/2017, declaring income at rupees 8,01,508. The case was selected for scrutiny and assessment under section 144, 143 within bracket 3 of the Income Tax Act 1961 was completed on 21/12/2018, determining the taxable income of rupees 35,66,191 against declared income of rupees 8,01,508. So they have hold that assessment year 2016-17 was filed by the company, and we had shown income of 8,01,508. They had done an assessment and they came to the figure of 35,66,191. Now, lordship will kindly come to para 6, your lordship. That is the main allegation, your lordship. That in view of the above, the Commissioner Income Tax, Mr. So-and-so, satisfied and of the opinion that assessor had made willful attempt to evade tax under the provision of the Act, and accordingly it is liable to be prosecuted under section 276D/277 for false statement and verification of return of income filed under the Act, and for failure to produce accounts and documents willful by not complying with the statutory notices issued and served on him. So they have said that we have willfully not provided. So this complaint, will kindly take note, was filed on 5th day of March 2019, your Honor. 5th March 2019. And the allegations are at para 6. Thereafter, your lordship will kindly come to page 28 when cognizance was taken.
Page
28. Lordship will see dated 15/7/2022. Complainant is represented. Perusal of the complaint petition and materials on record, finding prima facie material to exist, cognizance of offense under section 276D/277 of the Income Tax Act 1961 is taken against the accused Flamingo Breweries Private Limited. Complainant to take step to issue summons. So lordship will see cognizance, even though the application was filed and they sought for
certain sections under IPC and under Income Tax Act. Cognizance was taken under 276D and 277 of the Income Tax Act. Now, I will come subsequently, Your Lordship, but Lordship will kindly see the time period. One was on 5/3/2019, the complaint was filed, and cognizance was finally taken on 57/2022. So, Your Lordship, nearly 3 years old, Your Lordship. In between, they were absent on a sizable period. Lordship, I'll come to that. Why it has happened. Now, the cognizance, Your Lordship, the complaint was filed based on an assessment order, Your Lordship, which they had referred. That is at page 29. Lordship, have it. This is Office of the Assistant Commissioner of Income Tax, Circle, Tinsukia. The assessment year is mentioned, Your Lordship, 2016-17, and it dated is 21/12/2018. The assessee furnishes return of income for assessment year 2016-17 on 17/10/2016, disclosing an income of rupees 8 lakh. The return of income was selected for scrutiny through cash. Accordingly, notice under section so and so the Income Tax Act was generated through ITBA and assessee. Subsequent notice were also served. Let's see the relevant portion. Will yes. Last para, Your Lordship, of page 29. The assessee uploaded the schedule to the financial statement. Certain discrepancies were observed in the figures of balance sheet and profit of loss account with the schedule of the notes on financial statement. The assessee was asked to reconcile discrepancy by issue notice of dated so and so. Assessee was asked to reconcile discrepancy by 12/10/2018. There was no compliance till 14/11/2018. Lordship will kindly come to the findings, Your Lordship. That is in the last part, third paragraph from bottom. In view of the discrepancies in figures of the balance sheet and profit and loss account with that of the notes on financial statements, as mentioned in the so-called notice reproduced above, I reject the books of the account to the assessee under section 145 within bracket 3 of the Income Tax Act 1961 and proceeds to assess the income of the assessee under section 144 of the Act. Sri Ramnivas Agarwal, proprietor of Messrs. Mohit Enterprise, Pen so and so, is a distributor of IMFL assessee in this charge. Turnover of Messrs. Mohit Enterprise during assessment year 2016-17 is rupees 33.65 crore and net profit is rupees 1.88 crore. Thus, Messrs. Mohit Enterprise has disclosed a net profit percentage of 5.6%. Messrs. Flamingo Breweries Private Limited, Lordship, this is important, Lordship will note. Messrs. Flamingo Breweries Private Limited is a retailer of IMFL having turnover of rupees 5,945,586. Considering that the net profit margin in retail trade is much more than that of a distributor, I consider the net profit margin of Messrs. Flamingo Breweries Private Limited at the rate 7% of rupees 5,945,586 to the best of my judgment. So he held us that we are a retailer and he has taken your profit as 5.6%, considering another retailer. Now, Your Lordship will see. In view of the discussion made above, income of the assessee is assessed under section 144 of the Act at rupees 35,66,191. 7% of 5 crore 9 lakh so and so. Calculation of tax is made on ITBA. That calculation sheet form part of the order. So, Lordship, here, Your Lordship, what has happened? We are actually a bonded warehouse. We are not a retailer. So, the bonded warehouse, Your Lordship, we get the stock directly from the manufacturer. And the retailer, they pay excise duty and they take from us. So, their profit is much, margin is higher than the bonded warehouse because we are a wholesale warehouse. So, we were aggrieved by this order, Your Lordship. We filed an appeal before your Commissioner of Income Tax appeal at Dibrugarh. That is at next page, page 32, Annexure D. we filed an appeal against the order of CIT, Tinsukia, your lordship, before CIT appeals Dibrugarh. And this was, date of order was on 28/2/2020. So here, our submissions, your lordship, is at page 35. We responded to all the submissions. We responded, your lordship will kindly see. Roman 1, regarding notice dated so-and-so, the notice under section of the act dated so-and-so was duly complied with, and details and particulars were furnished online on 4/5/2018. Copy of acknowledgement number so-and-so is also enclosed. Roman 2, your lordship, regarding notice dated 25/9/2018, was also complied with, and all the requisite information particulars were furnished on 20/10/2018. So mostly it was furnished online, your lordship. So there was some confusion. Then at 3, your lordship, regarding notice dated so-and-so, the appellant Bexo submitted both these notices were not complied with, as Sri so-and-so, who was given the responsibility to look after, this was a CA, your lordship, suddenly left the job. So this is one ground we have taken at that point of time. The appellant further Bexo stated, in addition to the above notice, he had also received a notice manually, which was also complied with on 17/8/2018 by sending the requisite papers to the official mail ID. Copy of mail ID is enclosed for your perusal, Annexure C. So we have some.
Okay, that was a submission before the commissioner.
This was before the commissioner of appeal.
During appeal.
Yes, appeals are
During appeal. And now you tell me what are the grounds here for pausing the entire proceeding?
Yes, your lordship, I'll tell. So what has happened?
And what is this that case is pending now?
Now,
this case?
Now what has happened? Commissioner of appeals, we approached the commissioner of appeals. Commissioner of appeals gave us.
No, the complaint has been filed before the season.
Yes, before the season.
Cognizance is taken.
Cognizance is taken, your lordship.
Now, at what is this? That proceeding is pending.
That proceeding was stayed by your lordship.
Stayed,
your lordship.
The stage is appearance.
when?
So stayed is appearance. We had approached this court after cognizance was taken, and
Okay,
it was stayed by this honorable court.
okay.
So the reason.
When the order was passed?
Lordship, in regard to, it was the other two, the directors were passed earlier, your lordship, much earlier. And if your
Order for
lordship will
stay.
try and see.
Order for stay.
Stay.
Last one.
Yeah, last order was regarding Flamingo. And in regard to the directors, we were passed earlier, your lordship.
Okay.
Your lordship perused the last order, 3/6/2006.
Okay. The proceeding is stayed.
Proceeding is stayed. Lordship has stayed the proceeding and fixed it for hearing. Because here is a case, your lordship, we from CI, from Tinsukia, we went to appeals in Dibrugarh. In an appeal stage, your lordship, order was passed saying that they are not, that was wrongly your calculated, they are not a retailer. So they should be calculated as a bonded warehouse. So our percentage came down. So the moment the percentage come down, your lordship, then our income from 35 lakhs, it become 11 lakhs. And we had shown 8 lakhs. But since your lordship, we were not satisfied entirely with the order of CIT appeals. So we went before the income tax appellate tribunal at Kolkata bench. At Kolkata bench, your lordship, then remanded back the entire matter. They remanded back the entire matter, saying to the AO, there you do afresh. And then AO passed the fresh assessment order, your lordship. That assessment order is also, lordship, we have filed an additional affidavit. And fresh assessment order, your lordship, there was your lordship was, we were told to submit a penalty of 10,000. That also we have submitted. And then there was an amount of around 1,20,000 demand was there, which when we approached, we were told that actually already there is your tax at source is still around 4 lakh is there. So in fact, we'll get some refund back, your lordship. So the assessment order based on which, your lordship, the criminal proceedings, the cognizance was taken, that is already gone. So their foundation is already gone, and a fresh assessment order lordship will kindly take up my additional affidavit. That is at page 74. This is the fresh assessment order.
Is there any difference between the fresh assessment and the earlier assessment?
Yes, your lordship. Fresh assessment order, they have come to the finding, your lordship, that
Page number 74 is the fresh assessment order.
74 is the fresh assessment order.
Okay. What is the amount?
Amount is now is at page 76, your lordship, 6.3. That is 11,87,000. Thus the net profit of the SSC is estimated at the rate 2.33% of the turnover of the business of the SSC of rupees 5 crore. The turnover is same, which comes at rupees 11,87,032.
Okay.
So first assessment order, it was around 35 lakhs, your lordship. Now it has come down. Now from here, lordship will kindly see, come to next page, your lordship. 6.6 penalty proceedings under 271 within bracket 1, so and so is being initiated separately. Penalty is already imposed, your lordship. For concealment of income, penalty proceedings under section 271 within bracket 1B of Income Tax Act 1961 is being initiated, non-compliance to notice under so and so.
Penalty proceeding initiated, and you have also paid the amount.
Amount, your lordship will kindly see the challan at page 8.
Page
80, your lordship. Page 80, your lordship, this is the outstanding demand of 10,000. There were two demands. 10,000 we have already paid. And thereafter we sent an email, lordship will kindly see. And this fresh assessment order has come right from the National Faceless Assessment Center, Delhi. And lordship will kindly see our email at page 81. We have written to them, to the income tax. Lordship, may I read? Issue description, number so and so amounting rupees 1,20,000 and reference number so and so amounting to rupees 10,000 only for the assessment year 2016. In this regard, we'd like to state that as per order passed under section 144, read with section 254, read with section 144B of the Income Tax Act dated 24/3/2022, a total income of rupees 11,87,030 write so and so number. As per this current order and computation made at your end, rupees 76,510 is refundable after cross adjustment. Moreover, we have made a payment of rupees 10,000 against reference number so and so. Therefore, we request you to rectify and remove the demands which are reflected in Income Tax Portal. Regard so and so, Director Flamingo Brewery Private Limited. So we have requested them. They have neither replied to our petition. They have not replied to our additional affidavit. Now, your lordship, if the
whether
yes.
On the basis of the new assessment order,
lordship,
the respondents are required to withdraw the earlier complaint and to file a fresh one.
In my humble submission, the complaints which are filed and based on which cognizance was taken, it has no legs to stand because the assessment order is already gone. Lordship, assuming for a moment, your lordship, that your lordship do not interfere, we proceed before the lower trial court below, your lordship. Then the entire case is dependent on the assessment order, first assessment order. Now
that assessment order is no longer there.
That is no longer there, and they have not placed any additional material to say that to cover 277 and the other sections of income tax.
No. In view of the subsequent assessment order, whether those sections are not applicable to you?
Now, in the subsequent assessment order which is there, if the court below has to take cognizance, that has to be entirely a fresh matter, your lordship, and that we have already complied, the penalty. 10,000 we have already paid, and around 4 lakh of my income tax as deducted as source is already there with them. All they need is to deduct that amount, and in fact, I will get that refund, which I am claiming, your lordship.
Okay.
So
therefore, this complaint has to be quashed.
It has to be quashed, and I have some judgment, your lordship. And another interesting fact, your lordship, is that when they filed the complaint petition, after that, all these developments have taken place. They have not appeared before the learned court below, your lordship. After the fresh assessment order, after the assessment order first assessment order was remanded by ITET Kolkata. Thereafter, your lordship, they have appeared, and then cognizance was taken. So that is why I was initially stating, your lordship, that the fresh assessment order was remanded back on 24/3/2022 by the ITET Kolkata. And the cognizance was taken on 15/7/2022, after nearly around 4 months thereafter. So they could have highlighted this aspect to the learned court below, that already we have from CIT your.
No, before taking cognizance of the case
Lordship.
on the complaint filed by the Income Tax Department,
Lordship.
the second assessment order was passed.
No, your Lordship, the ITET Kolkata order, which remanded back the entire matter to the AO to consider it afresh and pass a speaking order was passed. And so they knew about that. So they knew that already the entire matter has been remanded back. But they did not place those.
During that time, the cognizance was not taken by the court.
No, cognizance not taken because if
Subsequently taken.
Subsequent, they have not appeared only. And that,
Okay, but before the second assessment order, cognizance was taken.
Before the second assessment order, cognizance was taken. But your Lordship, the ITET order, which remanded back the matter to the AO, that was before the cognizance was taken. So if your Lordship will see the ITET order, which is there, which remanded back, that is your Lordship.
No, they have remanded the matter back, whether they have set aside the order.
Yes, Lordship will kindly read the, Lordship will take you to the ITET order.
Page number?
Lordship, it is there.
142.
It's at 42. It starts at 42, your Lordship.
No, my question is whether the earlier assessment order was set aside by the ITEC.
Yes, your Lordship. I'll just state the words of the ITET, your Lordship.
Page number?
Page number 42. The relevant portion is at 43, your Lordship. I'll just read para 3 and paragraph 4. At the outset, Learned Counsel for the SSC has invited my attention to the impugn assessment order and submitted that no proper opportunity was provided by the learned assessing officer, in short the learned AO, to the SSC to reconcile about the figures of account. He has mentioned in his assessment order that...
Okay, all right.
Now,
the 4 is very clear.
4 is very clear, your
Okay.
Lordship. Is set aside
Yes,
and the matter is restored to the file of the learned AO.
So on the date of taking cognizance, the first order, first assessment order was not there.
No, Lordship. On the date of taking the cognizance, even the second assessment order was also passed. Cognizance was taken on 15/7/2022, whereas the second assessment order was passed in March 2022.
Yes.
Then?
So cognizance was taken subsequently.
Yes, that is what I'm saying.
That is what your
Second assessment order was passed and thereafter cognizance was taken. Because just some time ago, my learned counsel said, senior counsel said that the assessment order was second assessment order was passed after taking the cognizance, which is not correct. The second assessment order was passed prior to taking the cognizance of the.
Then on the date of taking cognizance, the first order was not there.
First order was not there.
So your case is based on the first assessment order.
Yes.
Then can you maintain this?
Yes, Lordship, my case is very good.
Your first assessment order was passed in 2018.
Yes.
It is based on the first assessment order they have filed a complaint, which was remanded back by the ITET Kolkata in 18/3/2021. And in fact, your Lordship, the fresh assessment order was also passed. It was passed on 24/3/22. So the fresh assessment order has been passed, and 15/7/22, the cognizance was taken. Now the cognizance was taken was based on the first assessment order, not on the second assessment order. Lordship will kindly see their petition. That is taken. Let him place, because they have taken based on the first assessment order, not on the second assessment order.
No. If on the basis of subsequent assessment order, they have paid the penalty, then can you maintain this proceeding?
Yes, Lordship. I can. If his submission is complete, I'll be submitting all together at all.
Lordship,
Because certain conceptions are required to be clarified, Your Lordship. Certain confusions and conceptions are required. Number one, prosecution is not dependent or subject to payment of the penalty or the tax amount. Prosecution is completely separate and independent, whether the penalty is paid or not. Number two, after his, if he is
you cannot at the same time ask him to pay the penalty and also you can prosecute him. Is it
yes, Lordship.
permissible?
Yes, yes. Both goes parallelly. Both are on different occasions.
No, first they should
It is
decide
not that
which-
once who has paid the penalty, prosecution will not be applicable for him, or if one has been prosecuted, he is not liable to make the payment of penalty amount. It is not that. Both are completely separate, both are completely different, and both are parallel.
Which provision is there?
276D and 277 of Income Tax Act.
270.
Lordship, one more thing I may be allowed to submit. By not beating the stick around the bush, Your Lordship, the prosecution which has been initiated, it is not depending on the income shown, it is not depending on the tax, it is not depending on the evasion of it. It is depending on the conduct of the client of the SSC at the time of the when he was called before the assessing officer. It is all about that. 276D deals with failure to produce accounts and documents. May I give a brief description of the case first of all?
He has already.
No, there is a difference, Lordship. There is a difference.
276D.
6D.
276.
Merit.
Yes.
Failure to produce accounts and documents. If a person willfully fails to produce or cause to be produced on or before the date specified in any notice served on him under subsection 1 of section 142, such accounts and documents as are referred to in the notice, or willfully fails to comply with the direction issued to him under subsection 2A of that section, he shall be punishable with rigorous imprisonment for a term which may extend to 1 year and with fine. This provision is not subject to any payment of any interest liability, tax liability, or any penalty liability. This is when you are required to call before any authority of the income tax to produce certain books of accounts or other documents. You are required to do that. If, for example, if a bank is required to call that you give certain details or accounts of this particular SSC, he is bound to provide that. If the bank does not provide those documents, they will also be prosecuted under this provision. So this provision is about providing certain documents and books of accounts to the assessing officer. And more importantly, the documents the provision says that if he does not provide the documents, based on best assessment, the judgment will be done. It might be a position that in the end of the assessment, there will be no liability. There will be no tax liability, no penalty liability, no interest liability also. Still, this 276D will stand because it is about the conduct of the SSC, whether he has cooperated with the proceedings of the assessment or not, whether he has provided his books of accounts and documents or not. And it is more important over here because why the file of the SSC was taken and chosen up for scrutiny. This is the most important thing. The Lordship may kindly come to the assessment order at page number 29. May. Last paragraph. The SSC uploaded the schedules of financial statements. Certain discrepancies were observed in the figures of the balance sheet and profit and loss account with the schedules of the notes of financial statements. The SSC was asked to reconcile the discrepancies by issue of notice under section 142(1). He was earlier directed to that there is a difference between your own statements, your PL account and your notes to accounts. Both are giving different amounts. The SSC was asked to reconcile the discrepancies earlier by 28/10/2018. Secondly, on 12/10/2018. Third, there was no compliance till 14/11/2018. Once more, notice under section 274, 271, 1B was issued to the SSC and penalty under section 271, 1B of the Act was imposed by the order dated 14/12/2018. On 18/12/2018, the SSC was issued final show cause notice, which reads as below. In final show cause notice, these were the ground why the case should not proceed in your absence, ex parte, and a best judgment assessment under 144 be initiated. Lordship may kindly peruse the difference. What was the difference? as your lordship got it.
Mm.
The difference, the table which has been given,
Mm.
short-term provisions, as per balance sheet, it was 24,86,000. As per note, it was 24,81,000. This is a small difference. Main difference is in number 5, tangible assets. As per PL and balance sheet, it was 26,831. As per notes, it was nil. Long-term loans and advances, as per PL and balance sheet, it was 29,500. But as per notes, it was 20,67,900. Based on balance sheet and PL, other non-current assets was 1,16,47,484. As per notes, it was nil. Short-term loans and advances, as per balance sheet and PL, it was 9,90,000. And as per notes, it was 1,05,99,084. So there were vast differences. So they were required to call. They were called by the assessing officer that you provide the reconciliation. Why these differences is there? This kind of reconciliation was required, and in which they did not cooperate at all. They did not produce. They did not come before the assessing officer for the assessment. And then accordingly, as per market trend, 7% was charged to tax, and the assessing officer filed the assessment order. So the proceeding was initiated thereafter based on these conduct of the client of the SSA under 271D, 276D. Number 2 is 277. What is 277? Merit. If a person makes a statement in any verification under this act or under any rule made thereunder, or delivers an account or statement which is false, and which he either knows to or believes to be false, or does not believe to be true, he shall be punished by this deception.
No, that's all right. But where is your finding that the statement given by him is false?
So the self-contradictory statements are there.
No. Whether a finding is not required that the statement given by him is false.
So here it has been mentioned as discrepancy. Falsity comes when on the basis of certain evidence it is found that it is false. Here it is discrepancy that two statements like balance sheet and asset and liability side must be equal. If there is a discrepancy among
you see, you have initiated criminal proceeding against him. So merely because some discrepancies are there, without there being a finding that the statement furnished by him is false, can you initiate the proceeding? You see, you have filed a complaint before a criminal court. Criminal prosecution and the other income tax proceedings are quite different.
Yes. Lordship, actually in financial matters, this kind of discrepancy implies a falsity.
No.
It is not required expressly. It has to be
criminal prosecution, this assumption, presumption, this will not do.
That
you have concrete evidence.
Yes.
That yes, the statement given by him is false. Where is that finding?
Lordship, when there is a culpable mental state in my favor and a
presumption is there in your favor.
Yes, Lordship.
That is there, but merely on presumption in criminal case you cannot convict the person. There must be some evidence.
Because if these discrepancies are not there and a false statement has not been made by him.
No, you see, in your complaint, where is the allegation against him that he has filed false statement? He has given false statement. Where is the complaint?
That word false is not there.
Not there. Okay, one word is there, that is conceal.
Yes.
Paragraph number 8.
False conceal is there. And try to cheat this office by showing fraudulent documents.
But where is the finding that the documents were fraudulent?
Exact words are not there. Because
and there must be a basis that these documents are fraudulent.
This discrepancy is the basis. When not small discrepancies, actually crores of discrepancies are there. This shows that there is a fraudulent. And number two, apart from this, The appeal was made before the Honorable CIT appeals.
Mm.
I'm not going about the tax liabilities. That is not at all relevant in the prosecution. The Honorable CIT reduced the amount on the basis of the market trend, taking the income as 2.33%. Thereafter, it went to the Honorable ITAT. ITAT set aside the order and transferred it for the restored before the Honorable assessing officer. The second assessing officer's order, Your Honor. May I also kindly put?
No,
Yes.
okay. First you answer my question.
Yes, sir.
That without there being a finding regarding concealment of the income, whether and in respect of the fraudulent documents, whether merely on the basis of discrepancies in the statement you can initiate the proceeding or not. What are the ingredients of the offense under section 276? What are the
276D, it is failure to produce accounts and documents.
276D and 277.
277 says one
statement
which he
in
believes not to
verification.
be true.
So you see the 77, 277, this if a person makes a statement in any verification under the act or under any rule made thereunder, or delivers an account or statement which is false, and which he either knows or believes to be false, or does not believe to be true, he shall be punishable.
He does not believe to be true. If he has given two figures for one particular account, so one is true and one is not true. On one side he is showing nil, and the other side he is showing 1 crore 6 lakhs.
Okay, let us do one thing. We will list the matter on Thursday. Correct. Those Arunachal matters are at 2 p.m. 2 p.m. Oh, we will list this matter immediately after motion column, motion matters on that day.
Okay, on 20th August.
Yeah. Yeah. We will list this matter as further. You come prepared. What are the ingredients of the section 276D and 277? You come prepared with the relevant
These 2 points
citation.
have been taken by surprise. He has not raised these points.
Pardon?
These 2 points have been taken by surprise upon me because these were not the issues raised by in the complaint petition, in the criminal petition.
Maybe even then we have
Yes,
to
we can
see the
discuss
thing.
Entire thing was
Yes, we can
decided
discuss.
by the ITAT, Your Lordship. I have two judgments which I am relying on.
Okay, on that day.
I will place it on that day.
Alright, Mr. You are Mr. Raskwa.
V. Rajpal, Your Lordship.
Learned counsel for the petition, and Mr. Supra for the respondent. Heard in part, list the matter on Thursday. Immediately after the motion matters. Okay.
Bye.